Royal Commission is now in session. Please be seated.
Now, our appearances are still the same? All right, thanks.
Your Honour, I appear with Mr Freeburn.
He always has to say everything twice.
Commissioner, I appear with my letter friend Mr Glover for the Commonwealth today.
Thank you.
And may it please the Commissioner O'Neill, I appear for the witness, Ms Pulford.
Mr O'Neill.
Commissioner, I have some updates, if that's of assistance.
Yes, thank you.
The Commonwealth confirms it will not be appealing your ruling on public interest immunity that was foreshadowed yesterday or communicated yesterday. And I anticipate one of the things that will fall from that is that Mr Gregory will seek to tender Exhibit 5, which was part of the material produced by Mr Jones yesterday.
So something was marked...
Or Exhibit E, sorry, Exhibit E,
yeah,
yes.
Yes, okay.
That's the first thing. The second thing is that, regrettably, briefly yesterday, in the course of examination, and I apologise, I didn't note about it until after the hearing concluded, Mr Jones's residential address was shown on the live stream broadcast. I understand that steps are being taken to ensure that there is not a repeat of that with respect to any further witnesses. But given that is the case, so that steps can be taken or those steps that have been taken can be confirmed, I seek a non-publication direction in respect of his residential address, and
yes.
then the video could be edited.
I order that Mr Jones's residential address not be published in any form arising out of these proceedings, clearly.
Commission, please. The third matter is that Mr Brown, who was listed as the fourth witness today, has been provided with additional emails. It is taking some time for him to review and for me to be satisfied that he has all the emails that he ought have. I've had some discussions. I've brought that to the attention of Mr Gregory, and to deal with that efficiently, we're proposing that he may go over either to tomorrow or Friday, so that can be, any material can be provided and proceed in an efficient manner, subject to your
Yes, but is there anyone we can go on with if Mr Brown's not available and we run out of witnesses?
There is Ms Pulford, who is present.
Yes, I understand that.
Perhaps a couple of hours. Then the witness, McGuirk,
Yes.
is to be called today. And finally, the witness Keeling, although some issues in respect of Keeling's documents have been unresolved as well. There was approximately 40 which hadn't arrived, but they were delivered late yesterday. There was some claims of PII and LPP over those documents. The PII claims have been resolved, but there are 16 legal professional privilege claims which remain unresolved, although I'm told they are being looked at. But that is the limit of where we could get to today.
All right, thank you for that. And Exhibit E will now form part of... What did you say? 66?
64.
64, thank you.
Commissioner, with respect to those 16 documents, if those are the 16 documents that were part of communications last night, they're the ones that my friend didn't know, I'm seeing heads being shaken. Commissioner, I will sort that and confirm what is waived. I can't imagine that there's terribly much that's left, but I'll have that confirmed before the witness is called.
Thanks for your help, Ms Hogan. Yes, Mr Gregory?
Yes, thank you. Just before Ms Pulford is affirmed, and to complete the narrative in respect of what Exhibit E has now become part of Exhibit 64, I can inform the Commission that Exhibit E comprises an email trail with attachments. The email trail commences on 23 January 2015 from Melissa, M-A-L-I-S-A, Go Lightly, to Kath Halbert, which identified that there was time spent yesterday on the fraud and compliance options for a draft brief for Minister Morrison, and that there were revisions to a draft. The next email is from Murray Kimber to two recipients, a Rob Barringer and a Tracy Carroll, copied to Serena Wilson, Paul McBride and Kath Halbert, which identifies that there are potential legal issues with one aspect of the brief to the Minister that is described as the PAYG clean-up, which is something that later became the Robodebt scheme. And then the final email in the trail is from Mr Kimber to Ms Dalton, Mark Jones and Anthony Barford, which identifies that payment compliance has just become a feature of this budget. That email trail, of course, explains what Mr Jones was not able to explain yesterday, which occurred between receiving the policy advice and legal advice in December 2014 and then receiving budget information and projections about it in April 2015. And it explains why perhaps he wasn't surprised to receive those projections in the email after this had gone to the Minister. The attachment to the email, the last in the series, is a Department of Human Services executive minute in draft form. It's addressed to the Minister for Social Services, who was at the time Minister Scott Morrison, and it contains a raft of proposed measures for inclusion in the budget, one of which was the later budget announcement in May of 2015.
All right, thank you.
As I indicated, Ms Pulford is present and available to give evidence and will take an affirmation.
Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth and nothing but the truth?
I do.
Thank you.
Take a seat, thanks, Ms Pulford. Mr Gregory?
Thank you, Commissioner. Commissioner, you were provided with a tender list for day 3. Exhibit number 65, at least as in terms it's proposed, is document DSS.5031.0001.0108. I tender that document. It was an email referred to by Mr Jones yesterday where he said he had seen an email which forwarded material to Ian Joyce from Mr Whitecross to Serena Wilson and Ian Joyce.
Right, that is Exhibit 65.
The Commission might note that the email was forwarded if the top passage of the email, 19 January 2015 at 6:50 could be pulled out. Commissioner, you will see that Ms Wilson replied to Mr Whitecross and said, "Thanks, I was concerned when Melissa described it to me. I will go back to Melissa and let Finn know." S. Melissa, as I understand the reference in that email, is Melissa Golightly, to which I referred, although her name there is misspelt.
Yes.
Thank you.
Now, Ms Pulford is probably wanting to get on with
Yes.
it. She's been sitting there for a while.
Your name is Anne Pulford?
Yes.
And you received a notice to give a statement and produce documents identified as NTG-0028.
I take your word for it, Mr Gregory.
And you prepared a response, a statement in response to that notice?
Yes.
And you also received a further notice, 0067, and you prepared a statement.
I received a further notice and I prepared a further statement, yes.
And there were various documents which were attached to your statement or referred to your statement. I tender, Commissioner, the documents contained on the draft list in the order they appear from 66 through to 135.
Yes, the documents will be marked in accordance with full from 66 to 105, you said?
135.
135.
Commissioner, if I may, I'm sorry to interrupt. I don't have this list. I have asked for it, hoping it can be provided to me shortly. Thank you.
Hold on a minute, I'll just check. Right, have this one.
Thank you, Commissioner.
Ms Pulford, could you describe your role in the Department of Social Services from about 2014 onwards?
Yes, I was a principal lawyer engaged within the legal services area of the Department of Social Services throughout that period, and I advised, my teams were responsible, and I advised in relation to social security, amongst other things.
How many legal teams were there in the Department of Social Services during that period?
Many at differing times. Approximately 5 would probably be the smallest, and at times it may have been as many as 7 or 8.
Throughout?
Sorry, can I just stop you for a minute? I thought I'd better check. Mr O'Neill, have you got a copy of that exhibit list?
I have the advantage of having the list, so I'm head of the Commonwealth.
Thank you.
Thank you.
Sorry, go on.
You indicated there was a number of teams, ranging from 5 to about 8 during the period. During the period, though, was your team, or the team of which you were a part, responsible for advice on what became and what was the Robodebt scheme?
Yes.
And throughout late 2014 through until at least 2018, you had direct involvement in advices in respect of that scheme?
Yes.
The commencement of your association with the scheme began in 2014 when you were asked for advice by Mark Jones.
With hindsight, yes.
Yes. It wasn't, of course, known by that name at that time. It was a proposal from the Department of Human Services about data matching and debt creation.
Correct.
In broad terms. I ask that Exhibit DSS 8.000.0001.0603 be placed on the screen.
And does that have a regular exhibit number? Or?
It now does. Although I can't presently locate it. 72. Thank you. Ms Pulford, the advice which the Commission has seen refers in the last line, or the second last line, to you, to the advice being second counselled by you. Is that a phrase that you are familiar with?
Yes, yes it is.
This email, Exhibit 72, appears to explain that in a little more detail. If we go to the middle part of the page, an email from Simon Jordan to you, we can see that on 17 December 2014 at approximately 10 a.m, Mr Jordan sent you an email which said, "Hi Anne, grateful if you could second counsel this advice. LEX is 25734. Firstly, what is LEX 25734?
LEX is the matter management system that the practice used at the time to keep track of matters.
Right. That was a location, an electronic location where you could find the advice?
It was a reference to where it could be located in the filing system, yes.
All right. And below that email was a draft of Mr Jordan's advice, which he was effectively asking you to review.
Yes.
Now, if we just hold that screen there, we can see that there are a couple of words in the second last paragraph which are struck through. You'll see the words "what" are struck through. And if we go over to the next, and in the first line under reasons, there's the strike through of the word "for." And if we go over to the next page, we can see that the advice comes over the top of the next page and then completes it in draft form at least, but refers to you as the principal legal officer who has second counselled the advice.
Yes.
And if we then go back to the first page and to your response at the top of the page to Mr. Jordan, thank you. We can see your reference there to a suggested removal of about 3 words, only which were marked below, and those were the ones which were identified as being struck through.
Yes.
But what you are conveying by that email in response to Mr. Jordan is that you have perused the advice, you were happy with your name to be attached to it as the nominated second counsellor, and that you considered that the advice was sound from a legal point of view.
Yes.
Commissioner, could I just have the document brought down? My understanding is that all phone numbers and personal contact details were to be redacted from documents. And I'm just noting that that version of the email has got, presumably now, dated numbers, but
numbers nonetheless.
if I could just have that pause for a moment while that's confirmed. And I am just informed that there are mobile phone numbers in this version of the document that have not been redacted. So I anticipated there was going to be a standing non-publication direction, but could I just confirm, was that shown? Given it was shown, could I have the phone number, the mobile phone number of Mr. Mark Jones, a non-publication direction in respect to that?
Yes, there's to be no publication of the personal contact details of any witness shown in any of these emails.
Thank you, Commissioner.
But what's happening about redaction? Can you help us, Mr. Gregory?
Yes, redaction, I understand, was undertaken in respect of a lot of the documents, but for some that extended to redacting email addresses within the department, which tended to obscure where the witness was or the source of their position. Perhaps if what I do is just, it might be taken by the document managers that I'm referring to a redacted document where it exists, and if it doesn't exist, then the direction that Your Honour just made would apply. Sorry, that the Commissioner just made would apply.
Yes, but ideally nobody would ever see a phone number on the screen, certainly not a mobile phone number.
That's right, yes.
All right.
No doubt those assisting the Commission have heard Your Honour's the Commissioner's
I realise
observation.
it's an enormous task given the amount of documentation to try and track down every number, but it certainly should be attempted.
Yes.
All right.
In short, Ms Pulford, we reached the point where you were satisfied that the advice drafted by Mr Jordan in response to the questions was one which was legally sound and one which you were happy to have your name attached to.
That is what the document indicates. I don't independently recall that now.
If we go back then to Exhibit 2, DSS.50003.1833_R, thank you. You have in the preparation of your evidence reviewed this document, which is the final version of the advice as it was forwarded to Mr Jordan.
Yes, I believe so.
If page 3 of the document ending 1835 could be produced, and Item 3 out of items 1 to 6 in the second half of the page could be called out, please. Thank you. Ms Pulford, the original version of the question that was asked by Mr Jones of you, which I think you forwarded to Mr Jordan for his response, which we've seen, asked this question: as income reporting is a fortnightly obligation, debt raising is also done on a fortnightly basis. The proposal would take an annual or defined period of time and evenly assign a proportion of the income across the period. Debts would then be calculated on this basis. Would a debt amount derived in this way be legally defensible in a tribunal court? And you were familiar with the form of the question at the time the response was drafted?
From my review of the documents, yes, I assume so.
All right. And if we go back then to page 1 and call out from high mark down to the end of the sentence under short advice. Thank you. This was the summary. The question there in the first paragraph is described in an abridged form or an abbreviated form, and that is whether a debt amount derived from annual smoothing or smoothing over a defined period of time is legally defensible. But I take it at the time that this advice was prepared, you understood the context in which the question was originally asked and were answering that question.
Based upon my review of the documents rather than independent memory, yes.
And you refer there to consultation with the Rates and Means Testing Policy Branch. Again, we'll come to that in due course, but you are familiar with that branch within the Department of Social Services from your period of employment there?
Yes.
And their input generally into policy matters related to at least this topic and a number of other topics?
Yes.
Right. The short advice there says this: in our view, a debt amount derived from annual smoothing or smoothing over a defined period of time may not be derived consistently with the legislative framework. Reasons are set out below, but before we come to those, is it the case that the answer to the question as it was phrased is essentially no? That is, a debt amount derived from annual smoothing is not legally defensible?
Broadly, yes.
Even though those words were not specifically used, that was the clear effect as you understood it of the advice?
Broadly, yes.
We go then down to the last substantial paragraph of the reasons commencing the proposal and have that called out. Thank you. You identify that the proposal may not be consistent with the legislative framework described above. Without going into the detail of that, would you agree with me that what is identified above in the reasons is essentially the entitlement provisions and debt calculation provisions contained in the Social Security Act for fortnightly recipients and fortnightly debts?
Yes.
Or correspondingly fortnightly debts?
Yes.
And in this paragraph, what you identify as the foundational factual point in that legal context, that in order to correctly determine a relevant debt, it would be necessary to consider the amount of income received in the relevant fortnight in order to apply the income test in that fortnight.
Yes.
And the proposal to average income from a broader period and allocate it equally to fortnights during that period would not lead to an identification of the actual amount of income that was received by the recipient.
Apart from unusual circumstances, yes.
Yes. And those unusual circumstances were not necessary to address in any detail in this advice because you were being asked a relatively broad question and the crux of the answer was no, and because the circumstances in which averaged income might be an accurate indicator of actual income would be very unusual or rare.
I agree.
Yes. Thank you. If we could have Exhibit 64 on the screen, CTH.400.001.2141 _R, if there is one. Thank you. And if we could go to the last page of this document. Sorry, the second last page. And then the preceding page. And that is the earlier page. We can see there at the bottom of that page that there is an email from Mark Jones to Ian Joyce and Sam Kelly. And do you recognise those names as persons in the Rates and Means Testing Policy Branch?
Correct.
Those who were referred to earlier in the emails about consultation on policy areas?
Correct.
All right. Now, Mr Jones has identified that he sought advice from that branch as part of his function, but it was the process that their response was provided to Mr Jones before Mr Jordan's response, which you second counselled, was provided to Mr Jones, correct?
Yes.
And if we can go to the page before this one, you had available to you, as did Mr Jordan, if we call out the passage under policy advice, that is the header of the email, you had available to you the policy advice contained in this email at the time that you second counselled Mr Jordan's advice.
Yes, from the documents, yes.
Yes. The policy advice was provided Friday, 7 November 2014, and the advice of Mr Jordan, which you second counselled, was provided 18 December 2014.
Yes.
Right. And so, prior to the consideration of the question that you were asked, there had been identified a number of points by the Rates and Means Testing Branch from a policy perspective which were very strongly against the proposal from DHS.
Yes.
And in the process by which you second counselled Mr Jordan's advice, did it appear to you that each of the policy points which had been raised in the policy advice were cogent ones?
I don't now recall.
You don't now recall? Having refreshed your memory from the documents in preparation for your evidence, does it appear to you now that they were cogent?
Yes.
If Exhibit 85 could be pulled up, ending 0607. Thank you. I may have given two conflicting numbers there. The document I was after was DSS.001.2141. 800.001.0607. Thank you. If the top part of the page could be pulled out. And Ms Pulford, you'll see that this is an email from Mr Jones to Mr Jordan, and copying yourself and Mr Kimber and Mr Barford in on the same date that the advice was received.
Yes.
And Mr Jones thanked Mr Jordan for the advice and indicated to you that we, as in his team, would summarise it, including the feedback from the means testing policy, and provide to Human Services as an explanation as to why DSS would be unlikely to support a measure that used annual income smoothing to calculate debts.
Yes.
And I take it that didn't come as any surprise to you because you understood the context in which the advice was being sought.
I don't now recall receiving the email.
Right. Can I just deal with the extent of your recollection generally then? You've indicated that you were involved in what became the Robodebt scheme from this point in 2014 through until at least some point in 2018. Do you have any independent recollection of your involvement?
I have independent recollection of a few points, but not comprehensively across the period.
All right. To assist me then, could you very briefly identify, perhaps only very shortly, which points you have some recollection of?
I have some recollection of my conversation and subsequent advice to Ms McGuirk.
Right, that was January 2015?
2017.
Sorry, 2017, yes, the advice you provided then.
Yes. And probably more recent advices, but the 2014 period I really don't have an independent recollection of now.
All right. Do you have any recollection of advices in 2017?
Having now reviewed them again, I have a recollection of the conversation. I have a recollection of the gist of the advice I provided. I couldn't say I recollect what I wrote at the time, other than by having reviewed the documents since.
And what about in 2018?
I really have very little recollection of 2018.
Very good. Thank you. I'm told this is Exhibit 87 for the record. Now, in terms then of your general recollection of the role, your team, part of its function, as you've said, was providing advice not only to DSS, but to DSS in respect of matters raised by DHS.
Yes, our primary function was to provide advice to DSS as our client areas, and
Yes.
that may have involved matters where DSS was dealing with DHS.
And in circumstances where the proposal, the subject of this advice, came from the Department of Human Services, you understood that context and no doubt expected that the advice that was given by you in conjunction with the policy advice from the Rates and Means Testing branch would be conveyed to DHS.
I would have expected that the gist of the DSS view would be portrayed to DHS.
Would you agree with me that the gist of the DSS view was a very strong no?
Yes.
Right. And where else would you have expected the advice that you gave to be reported to, or to whom might it be told about within DSS?
I would expect that the officer level persons that were seeking the advice from us would likely have escalated that within their stream. That would be the extent of, I think, my expectation.
All right. Can document DSS 80000001.1071 be brought up on the screen? Exhibit 100. On the 29th of January 2015, Ms Pulford, you were included back in an email loop from Catherine Dalton to Millie Wong, copied to yourself and to Susan Jura, DJURA, which included earlier emails, that is an email from the 16th of January 2015 and the original 2014 advice and the policy advice. And if we just go to the last page of that and continue to flick through, you can see that that effectively is what was conveyed back to you on the 18th of December by Mr Jones.
Yes.
All right. We go then to the top of the first page and pull out the first half, thank you. Can you just identify who Catherine Dalton is?
Catherine Dalton was at the time the director of the Debt and Compliance Policy Team, I believe.
Right. And at what level did she sit in the organisational structure?
She was an executive level 2, so she would have sat between an SES branch manager band 1 and an SES branch manager, an SES group manager band 2, and so on.
Right. What about Susan Jura?
Susan Jura was a fellow principal lawyer in the legal team in which I worked.
All right. Ms Dalton addresses this to Ms Wong. Sorry, I'm not sure I asked you where she fitted in.
You haven't asked me. Millie was a senior lawyer within the team.
Right. Ms Dalton says, apologies, I should have referred you to previous legal advice, which you will find below. So at least by this point, we can see that it has reached Ms Dalton. That's correct?
Correct.
And below that, we see Mr Jones' email to Mr Whitecross and Mr Kimber. Where did Mr Whitecross fit?
At the time, I believe Andrew Whitecross was the group manager, the SES Band 2, within the policy stream.
That is a level below Ms Wilson?
Correct, yes. Ms Wilson was a Deputy Secretary Band 3.
Band 3. And Mr Kimber?
I do not recall where Mr Kimber sat within the organisation.
Right. But given your experience in your team and the fact that your advice related to a proposal advanced by the Department of Human Services, this email, I take it, didn't come as any surprise to you that had gone up to the level of Mr Whitecross.
Noting, as I've said, that I don't have a recollection of that at the time, that's what the document indicates to me, yes.
But at least you were aware that it was a potentially significant proposal by DHS in terms of revenue?
I don't recall.
You only know what is contained on the document by way of background provided by Mr Jones?
Correct.
Would you agree with me that it appears from his background and the summary of the proposal that it was a relatively significant proposal in terms of potential income to the department or debt reduction to the department?
Based on the document, yes, I agree.
We move then to 2015.
Just before we do, why did Millie Wong need those advices? Do you know?
I don't now recall, Commissioner. Are you referring to the 2014 advice?
Well, the email says from Catherine Dalton to Millie Wong, I should have referred you to previous legal advice, which you will find below, which suggests she was working on something that she needed them for.
Yes, it does suggest that.
You can't shed any light?
I have, in my review of other documents, I have found review by Millie Wong of documents provided to our team by the policy team looking at the DHS proposals. So I would speculate that that is probably the context.
What do you mean review? I mean, this may all be covered later, but it's news to me. So what sort of review?
We would be asked at times to look at proposed briefs or other documents of a policy nature from a legal perspective to indicate whether there were any legal concerns.
And you think she was doing something of the kind?
Yes.
All right, thank you.
Do you recall how long Ms Wong was a part of the team?
It would have been approximately 3 years from memory.
From 2014?
I wouldn't say precisely from when it started. I believe Millie may have been in the team prior to that, but it's a long time ago.
If we turn then to 2015, this is Exhibit 87. 77, ending 0002, redacted version if one is available. Appreciating that you say you now have no recollection of these events in 2015, I'll take you through it. But if we start with the very top of the document and pull out the first passage, thank you, we can see that this is an email that you have sent to a David Hertzberg, copying Ms Wong, Ms Dura into it on Wednesday the 4th of March 2015.
Correct.
You can see that?
Yes.
Now, were you aware at this time that the payment compliance proposal, that is the one that was addressed by your advice, or the advice of Mr Jordan in December 2014, had become part of the budget, as it were, because advice from the Department of Human Services indicated that Minister Morrison indicated he wants a number of potential proposals in an attached briefing be brought forward for portfolio budget statements?
I don't have an independent recollection, but I have reviewed the documents relevant to my statement. This was amongst them, and I'm aware that there was a signed brief which indicates, as you said.
Right. That is, despite the clear no from the Department of Social Services on policy and legal grounds, at some time in early 2015, the Department of Human Services conveyed to the Department of Social Services that the Minister wanted a range of measures developed for portfolio budget statements for potential inclusion in the 2015-2016 budget.
That is what this document indicates.
And one of those was this particular proposal. When you became aware that despite the strong advice that you've referred to on policy and legal grounds, that the proposal was being advanced, do you recall whether you raised with anyone in your team, or indeed anyone at a higher level than you, Mr Whitecross for example, Mr Kimber, other persons at levels of seniority, whether in fact what was being proposed was inconsistent with the advice?
I don't now recall.
Looking back on your usual practice, having given such advice, or at least second counselled it as a principal legal officer, do you think it was within your duties to ask some questions about how this had come about?
I think it would be within my duties to talk to my client area, to discover how they were reacting to the response that DHS had given. It would not have been my practice to speak to Mr Whitecross or other persons more senior within the policy stream, because my engagement with my clients is with the officers generally at the same level within the policy stream who have asked for the advice, and I would expect that it would be the policy stream that would take the principal responsibility for managing what proposals were proceeding and the degree to which risk, including legal risk, was pointed out to more senior officers within their stream.
And when you refer to your client group, do you mean Mr Jones and his team?
Yes.
You don't mean DHS?
No.
Right. Well, given that it was within the scope of your duties to at least ask Mr Jones about what had happened between the advice and the information you were given about it becoming a potential budget measure, did you take that step?
I don't recall.
You can appreciate the significance of the advice that you gave in the context of being told that this was something that the Minister wanted progressed.
With hindsight, yes.
Well, surely you must have appreciated that at the time.
I don't recall that.
In any event, if we move to March 2015, the attachment is B15125, a signed brief to the Minister, and there is obvious discussion about consultations and reviews of something which are addressed below. That's right?
Yes.
Okay. And it seems that you had, at least so far as this email chain goes, been the last person to give the stamp to what was contained within it.
Correct.
That is, the stamp of approval.
Correct.
If we go then to the second last page of the document ending 0010, and pull out the lower half of the page commencing from Dalton. Thank you. And so starting in January 2015, Ms Dalton sent an email to you, copied to Ms Dura and other persons, one of whom is Joanna Carey. Where did that person fit?
Joanna Carey was then the branch manager of the legal branch.
Is that your immediate supervisor?
Yes.
And your colleague, Ms Dura?
Yes, my colleague.
And Mr Barford was also included as well?
Mr Barford was in the policy area.
The subject was a new version of the draft brief on fraud and compliance, and Ms Dalton addressed the email to you, and if the second paragraph can be pulled out. Sorry, the first paragraph commencing Minister Morrison. Thank you. It reads, Minister Morrison has requested that the DHS bring forward proposals for strengthening the integrity of the welfare system. DHS has developed the attached minute and, given the quick turnaround required to the Social Security Performance and Analysis Branch, has provided comments highlighting the need for legislative change as well as the shift away from underlying principles of social security law. What did that mean to you?
I don't have a direct memory of this.
Reading it now,
Reading it now, I see the email as seeking advice as to what would need to be done in order to allow, legislatively or otherwise in terms of the social security law, to allow the proposal to proceed.
right. And the need for legislative change was really the underlying theme, or inconsistency with current legislation was the underlying theme of the advice dated 18 December 2014. So
Yes.
the prospect that legislative change would need to be identified to get the proposal up and running, as it were, was no surprise to you.
Based on the documents, I doubt it would have been a surprise to me.
The next paragraph, if it could be pulled out, Ms Dalton says, I understand that Tony Barford has had some discussions with you regarding our concerns with the proposal. We would appreciate your scrutiny of the proposals and advice on any legal implications / impediments, what action would need to be undertaken to resolve legal issues, as well as some indication of the lead time required to obtain legislative change. Do you recall the conversation with Mr Barford?
No, I don't now recall a conversation.
Was it your practice to arrange meetings with Mr Barford electronically, that is by way of email?
Yes.
Have you had access to emails which might permit you to identify when the meeting occurred?
I have had access to the electronic system which may have identified that, but my solicitors undertook searches of relevant terms and no such meeting invitation has been identified.
Right. If we go to the page ending 0009, we can see at the bottom of the page you sent the email to Ms Wong, copied Ms Dura, and over to the top of the next page asked Ms Wong if she would mind progressing this with Ms Dura. That is, you were passing the responsibility for the preliminary draft to both of them to develop.
It is passing it the responsibility for the progression for the email from Catherine Dalton to Millie, yes.
Yes.
And keeping Susan informed.
Yes. And I take it by forwarding the email to them and asking both of those persons to progress it, you weren't relinquishing ultimate responsibility for the task that you'd been assigned?
I wouldn't regard that email as relinquishing responsibility, but asking a senior lawyer within the team to progress the majority of the work on it.
Yes. And as we saw from the very first email in the trail, it appears that you had reviewed some changes and drafting and they appeared fine to you.
Correct.
To put the next round of emails in context, if we can go to the page ending 0007, and just pull out the part in the lower section of the page commencing from Ms Wong down to the end of the paragraph starting "Thank you." Thank you. The response from Ms Wong then came on the 4th of February 2015 to Ms Dalton, and you were copied into it.
Yes.
And the introduction addresses the request for advice as to legal issues raised by a DHS brief on fraud and compliance, and identifies that because the description of the proposals in the brief was at a general level and that the details are yet to be worked through, correspondingly, only general comments highlighting issues could be provided from a legal perspective. That's right?
That's what it says, yes.
All right. And if we can then go over to the page ending 0009, at the very top, PAYG cleanup, and the comment below it could be pulled out. Thank you. And for context, what had been addressed between the paragraph we just looked at, indicating advice of a general nature, and this particular part of the email was addressing various aspects of the brief, of the draft brief to Minister Morrison, relating to different areas. But this part, point 7, related to what you understood would become the Robodebt scheme.
That is what the document says, and I now understand, yes.
All right. And in respect of that, the description of the proposal at this stage was PAYG clean-up, and the comment was, please refer to the advice by Simon Jordan dated 18 December 2014 in relation to this issue.
Yes.
Being familiar with the sequence of the emails, there was then an exchange which related to the question of some international obligations,
Yes.
which didn't have direct relevance to this particular point.
Yes.
But then we move to the 2nd of March and the page ending 0004. Thank you. And in the second half of that page from Catherine Dalton down to the bottom of the page, if that could be called out. Thank you. What we see is the continuation of the discussion between Ms Dalton and others to which you are copied. The subject, of course, is the same, the new version of the draft brief on fraud and compliance. And it was addressed to Mr Hertzberg. I can't recall if I asked you to identify him earlier. I don't think so.
No, I don't believe you did. Mr Hertzberg was another senior lawyer within the team in which I was a principal lawyer.
How many people were in that team?
I cannot now remember exactly, but my memory was there were 4 principal lawyers, of the order of 5 or 6 senior lawyers, and approximately the same number of lawyers.
So a total of perhaps up to 15 or so people in the team?
Excuse me, yes.
And I appreciate that that might have varied over time,
Yes, it did.
but a relatively small team nonetheless when there was a degree of collaboration.
Yes.
And this email trail reflects that various people within the team
Excuse me.
at the higher level, that is principal legal officer level, were involved in addressing the question about legislative change for the brief.
Yes.
The first paragraph reads, urgent advice is required as to the following strategies that have been cleared by Minister Morrison for DHS to take forward as an NPP. Now, an NPP is a new policy proposal.
Correct.
It is a proposal advanced by a department in anticipation of a budget,
Yes.
which might ultimately, in part or in whole, be included as a budget measure.
Correct.
And what we know now, from the benefit of hindsight, is that this particular proposal did become included in the 2015-2016 budget, delivered in May 2015,
Correct.
as the strengthening welfare integrity payment system. All right. Ms Dalton identifies what appears to be a significant gap in the advice in the second sentence. She says the checklist in DHS draft NPP states no legislation is required. Did that jump out to you as a significant omission in what information was being identified by the Department of Human Services?
I don't now recall, but I imagine it would have.
As Dalton continues, however, we are concerned that the strategies may require legislative change, brackets perhaps significant, and are seeking your advice as to the possible extent. I've included the email trail below with previous legal advices from the Public Law Branch. Pausing there, was that your branch or a different branch?
No, that was my branch.
Some of the initial advice was based on assumptions that have changed since that advice. Pausing there, are you aware of those assumptions and how they had changed?
No, I don't believe I am aware.
Right. The next introduction refers to the Department of Finance requirements and the need for at least preliminary advice by close of business Wednesday 4 March. Now that was only 2 days later. What are the Department of Finance requirements which are referred to there in the context of a new policy proposal?
I'm sorry, I don't know the Department of Finance requirements. I'm legal only and I don't deal with the finance elements of the briefs.
Did you understand in a broad sense that in order for a new policy proposal to be introduced in a budget to be delivered in May, some 12 to 15 weeks after this email, that there was a sense of urgency about addressing this question?
I would assume that now the timelines are very tight.
The timelines are very tight and the opportunity for considered legal advice in the following 2 days was very limited. Would you agree with that?
I agree, 2 days is short, yes.
And particularly given that it had taken at least some weeks to provide the 18 December 2014 advice, which might reflect the identification of a fundamental inconsistency with existing social security law, but also the many other competing demands on your team. Correct?
Correct.
And that it appeared that the very tight time frame and the pressure was coming from a clearance by Minister Morrison to have a new policy proposal developed to the point where it might be submitted to the Department of Finance.
Correct.
And even though you don't recall it now, having perused these documents, that's how the issue is emerging with the benefit of your experience.
Correct, yes.
The particular measure which was identified was the strengthening the integrity of welfare payments scheme, and there were various proposals contained under the heading Précis, and if we identify those by calling them out, that is Précis down to 1.2 billion. Thank you. The Précis contains a number of dot points, broadly described in the first as a proposal to increase the capability to detect, investigate and prosecute suspected fraud and non-compliance. You understood in the context of social welfare recipients?
Yes.
The fourth point was utilising new technology to increase data analytics, complex network analysis and geospatial analysis, and establishing a capability for real-time monitoring and risk profiling. Did you see that?
I see that.
Did you understand what was meant by that?
I don't now recall, and to be honest, I'm not sure I know exactly what that was intended to call out now.
No. The second last point is includes a focus on active confirmation by welfare recipients of information provided through an online declaration process. At least that point was broadly consistent with what you understood the proposal to be as it was described to you by Mr. Jones in November or October 2014.
I don't now recall, but based upon the emails that were sent, that is broadly consistent.
Broadly consistent. What hadn't been conveyed, it seems, in any previous email was the numbers involved in terms of investigations and interventions, the period of time and the estimated gross debt and savings. You hadn't seen that information before, I gather?
I don't now recall.
And in the time available to have your solicitors conduct searches for you, you haven't identified that information at any earlier point in time?
Correct.
All right. In any event, some very significant numbers were advanced there under the Précis. 900,000 additional fraud investigations, and gross debt and savings of $1.2 billion. Did that crystallise for you the significance of the measure to government policy? Did you apprehend it would be a very significant measure in terms of government policy?
I don't now recall.
If we go over to the page ending DSS 0005, that is the next page, and we see point 7 there, and if point 7 can be called out. Now, in this redacted version of the document, I can inform the Commission that the passage in brackets commencing "we need to know" at the end, concluding social security law, is in red font. Ms Pulford, just in terms of the different coloration of the documents, were you shown the colour version of the document?
Yes, I've seen the colour version of the document.
And to your understanding, who added the red font?
My understanding is it would have been Catherine Dalton.
Right. That is, she has reproduced something that appears to have been sent to her or received by her with her questions underneath what she has reproduced.
Yes, that's what I take the document to mean.
Very well. Point 7, of course, corresponds with the earlier point 7, which was very brief, where the comment was we refer to the December 2014 advice.
Yes.
And there is some elaboration on that at this stage, which identifies that the employment income matching part of the proposal involved increased PAYG matching with the ATO and subsequent advice to recipients that their income estimates is in error, placing an obligation, or rather the obligation, on the customer to ensure their record is correct by providing evidence to support their claim. This is designated to clean up outstanding variances between estimate and actual income prior to single touch payroll implementation. You see that?
I see that.
Now, were you familiar with the concept of single touch payroll implementation as a proposal in 2015?
I don't now recall.
No. But you understood, at least from the expanded terms here of point 7, that there was a shift to place an obligation on a customer to ensure their record was correct and to provide evidence.
Yes.
All right. And the phrase clean up outstanding variances is similar to the clean up phrase in the very limited version of point 7 to which we looked at before.
Yes.
Just to remind you, I appreciate you didn't have that point in front of you, but point 7 was described previously as PAYG cleanup. The question asked then in red in the square brackets by Ms Dalton was, we need to know the scope of the legislative change required to bring this into effect and any implications for the purpose and intent of social security law. And it was the review of those points which you ultimately reviewed and said the changes look good to you.
Yes. Yes, the review by David Hertzberg.
So if we go to those points then, and we'll commence conveniently at page ending 003. Thank you. And go down to the bottom of the page, proposal 7, which carries over to the top of page 004, and ask that that passage, proposal 7, over to the top of page 04 be pulled out.
I'm just a bit worried about the fact that Miss Hogan-Doran's not here and she's obviously not well. I'm wondering whether we shouldn't take the morning break to give her a chance to recover.
Yes, certainly. I'm looking in a different direction to Ms Doran, but
No, you're probably oblivious.
If I can assist, Commissioner, Ms Hogan-Doran has just stepped out momentarily. We're in the Commission's hands, but content to continue.
Well, it just seems a bit unfair, particularly if she's going to want to question Ms Pulford to proceed in her absence. So we did start a bit early. I think we might just now take the break till 11 o'clock.
thank you, Commissioner.
For a chance to recover. Sorry to interrupt you in mid-flight, Ms Pulford. But all right, we'll take the break.
All rise. The Commission stands adjourned for a 15-minute break. Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Thank you, Commissioner. Before the break, we were on a document ending 0002 and a passage on pages ending 0003 and 0004 had been pulled out, and they've been helpfully joined together. Now, this was the response from Mr Hertzberg, the other principal legal officer in your team to which you referred.
He was then a senior legal officer.
Senior legal officer. And it included addressing the extent of potential legislative change required to get this particular proposal into a lawful state, as it were.
Yes.
That is, to comply with social security law. What we can see here is that the proposal is now described employment income matching, and again, which is a reference to some earlier parts of the advice, but this is a repeat of it. There is an issue here about whether the proposed information sought from the ATO will occur as part of the data matching cycle currently enabled by the Data Matching Program (Assistance and Tax) Act 1990. If the information is to be obtained from the ATO in some other way, such as on a targeted basis with respect to certain high-risk groups, we would need to look carefully at the secrecy provisions in the taxation legislation, such as in subdivision 355 B of the schedule to the Taxation Administration Act 1953, to check whether the proposal would be consistent with these provisions or whether amendments would be needed. Pausing there. This was a significant issue from a legislative perspective, wasn't it?
Yes.
Because information could be conveyed pursuant to an act, the Data Matching Program Act, by the Australian Taxation Office to other agencies, including the Department of Human Services, but that act imposed some significant limitations or restrictions or conditions on it.
Yes.
That is, the use to which the enormous volume of data held by the ATO could be put. All that was identified here in terms of that document, in terms of the advice, was that this issue needed to be addressed and needed to be addressed in some detail. You would agree with me that it was a significant issue which was identified?
Yes.
Particularly where in circumstances from earlier information you were aware that there was up to 900,000 interventions to take place.
Yes.
That may not reflect an equivalent number of individuals, because individuals might have multiple categories of identified discrepancies from receiving different forms of social security over different times, but nonetheless there was a very significant number of people likely to be identified by that number of 900,000 interventions. You would agree?
Yes.
And in respect of the data used to identify discrepancies that might be held by the Australian Taxation Office, there was a real question to be explored about the use to which that data could be put. And that was what was identified at this point in the development of the new policy proposal by that paragraph.
Yes, the legal risks there.
And undoubtedly, had your team had further time available, it might have been able to explore to a great detail what the implications were under this, in respect of this significant issue, but time was of the essence because of the urgency about the proposal, which prevented anything more than identification of what is potentially a very significant issue.
Yes.
The passage continues that the information, that is, the information held by the ATO, is proposed to be awarded some sort of special status as primary evidence. That is, it was to be the source of the alleged discrepancy of payments and income. That's how you understood it?
Yes, that was the proposal.
Yes. That is, the concept of matching between matching income reported to Centrelink and income reported to the Australian Taxation Office by employers of persons who might have been on social security benefits.
Yes.
Mr Hertzberg said, "I'm not sure that the current social security law would accommodate this conception." And that was really the advice that you second counselled in December the previous year, correct?
No, I don't agree with that. The 2014 advice was about the legalities of using income generated on an average basis for social security purposes. It wasn't directly about evidentiary weighting of particular types of income.
All right. So this was, at least on your review of the document, an additional legal question which had been identified by Mr Hertzberg.
Yes.
He continued to note that, of course, a decision maker, that is a decision maker in respect of a potential debt, is required to look at all of the information that's available to the decision maker. You see his reference there?
Yes.
That's hardly a surprising proposition, is it?
No.
And that in the sense where ATO PAYG data might be used to calculate a debt, and that's the context in which you understood the policy proposal, Mr Hertzberg raised the question of whether amendments might be required to elevate the status of the ATO information as opposed to information available from other sources.
Yes.
He identified that rules might need to be inserted into the Social Security Act. That's legislative change.
Yes.
Which makes it clear, that is, the potential legislative change that would be required for this proposal would have to clarify that a person's employment income is defined really to be the amount of income sourced from the Australian Taxation Office, unless another person has provided subsequent information to indicate otherwise.
Mr Hertzberg is advising there's significant doubt that that is within the social security law.
That's right, because the Social Security law identified that income was income earned, received or derived during a particular fortnightly period, not what the ATO, according to an employer, might have said to have been received over a period and then averaged.
Yes.
He also identified a practical problem at the end of the paragraph, that there might be delays between a decision made on ATO data, which he described as primary, and that relates to the primary evidence point he made earlier, and revised decisions if other information became available at a subsequent point. And that there would need to be review rules put in to the arrangements to allow for what might happen if the primary ATO data was wrong and a person was later able to identify the error, but in the meantime there'd been some impact on their social security payments or monies had been recovered from them.
Yes.
So, at least as it arrived at this point, would you agree that in addition to that fundamental legal issue you identified with Mr Jones in 2014, there was a range of other problems which were apparent to lawyers within your team in respect of the new policy proposal from the Department of Human Services?
Yes.
If we go then to page 002, the first page of the document, we can see your review as it was provided to you. Thank you. And if the first part of the email at the top of the page could be called out, commencing, thanks very much. Thank you. You note that, of course, Mr Hertzberg appeared to work on it late because of the time pressures, and having reviewed his responses, you were effectively satisfied that they focused on legislative implications, which was the nature of the request that you had been asked.
Yes,
And beyond what was identified, you had no additional comments.
that's the indication in the document, yes.
All right. So that brings us through to the 4th of March 2015, where although the Minister had indicated a willingness to pursue it, and that was being pursued by the Department of Human Services, the DHS position on the legal front, to the extent of your knowledge, had not only not changed from December the previous year, but had identified a range of other problems with the proposal.
Do you mean the DSS perspective?
Sorry, DSS, I did mean.
Yes, correct.
All right. And just as we saw earlier with the 2014 advice that was looped back to you, there were some senior people who were interested at that point in time, that is senior within DSS. Are you aware, and if you are not aware, would you have expected that very senior persons within DSS would be made aware of this advice in early 2015?
I don't now recall, but I would have expected that senior persons would be made aware of this advice.
And it's more likely that they would have been made aware of this advice, would you agree, because the proposal had been advanced to the point where a minister had indicated an intention to pursue it, and a new policy proposal had been developed, and he had signed a brief about that proposal at an earlier point in time.
Yes.
That is, the significance of it from a legal perspective had gone from something between the two departments to something that went all the way up to the minister.
Yes.
Can I just raise another aspect of that advice? And what I'm thinking of is on page 3, the section under proposals where Minister Morrison has indicated further discussion. This includes possible fixed recovery fee. If that bit could be brought up, if you can find that, under the dark heading proposals where Minister Morrison has indicated on page 3. You've got the magic touch. Mr. Gregory, can you give the instruction? Can you see what I'm looking at?
I can't. Does your...
The light print at the top of the page is 003. I'm sorry, it's page 5. That's my mistake. In the darker print, it's page 5 at any.
Oh yes, the second half of page 5.
Yeah, that's it. So if you can just bring up that passage that's headed administrative sanctions.
That is point 2 under the dark heading, if that could be called out.
So you see that includes possible fixed recovery fee, Ms. Pulford? Do you remember that aspect of it?
I don't have a memory of what was discussed at that time, I'm sorry.
Okay, well, if we can go to page 3 of the document under proposal 2, administrative sanctions. And there's a statement there that new penalties or sanctions would need to be supported by new legislation. And specifically, it says that the ministerial minute itself appears to assume that amendments would be required, such as to section 1228B of the Social Security Act, to extend existing circumstances and overpayments that a recovery fee can be applied to. Can we assume that you were in agreement with that part of the advice also?
Yes, we can assume that.
All right, thanks. That's all I wanted, Mr. Gregory.
Thank you. Can I, before we move on, go back to the page ending 0005? Point 4 at the bottom of the page, commencing streamlining. Thank you. Again, point 4 here includes words in brackets at the end, which you understood to be added by Ms Dalton to the original email that was copied to her, and it identifies the question of streamlining prosecution referrals. Brackets could become critical. Now, at least in the copy that I've got, that's not marked in red. That is, the brackets could become critical, but it's consistent with the manner in which Ms Dalton identified her contributions to the document, so it may have been her as well.
Yes.
What it says is seeks to amend Section 192 of the Social Security Administration Act to enable information which has been gathered for administrative purposes to be used for prosecution without further warrant, and an amendment to Section 240 sub 2 of the Administration Act to increase the scope of the section to allow admission as prima facie evidence. The question asked by Ms Dalton was, are there also issues under the Evidence Act 1995, especially in terms of inducing self-incrimination? In the context, did you understand that this part of the proposal, relying as it were on data obtained from the ATO, averaged over a period to create an apparent overpayment and then requiring a recipient to engage online to explain it, really introduced questions about the extent to which someone might be compelled to provide information which might be used against them in a prosecution in respect of a debt?
Well, insofar as I was aware of the questions that were asked by Ms Dalton, yes, I would have been aware of that issue, and I expect that Mr Hertzberg addressed that in his response, although I don't have that immediately in my mind.
In fact, Section 192 was amended, wasn't it? Of the Social Security Act, to my recollection at any rate.
In the context of this proposal?
Well, that I'm not sure about, but it was subsequently amended to permit evidence to be used in that way, I think. You're not familiar with it? We'll check.
I'm sorry, Commissioner, I don't know.
All right, that's fine.
The document, if we go back to the very front page of it, identifies two attachments, one of which you have referred to already, B15125, Minister Morrison signed brief, a PDF document. Can you see that on your screen?
Yes, I can.
You can, all right. That's not attached because of the issues relating to the ruling yesterday, but we can come back to it. I just want to clarify with you, Ms Pulford, you've observed that signed briefing in preparation for your evidence.
Yes.
Is it the case that your recollection of the contents of that brief are limited to the brief itself?
Yes.
You don't have any independent recollection of it?
Correct.
Is the same with the second attachment there with the long number, which appears to be a draft NPP according to some text later?
I don't have a clear memory of that document.
All right. Do you recall that the advice here was sought in respect of a draft new policy proposal, and it's referred to in the body of the emails addressed below?
Yes.
All right. But again, beyond the contents of the new policy proposal or the draft, you don't have any independent recollection of its contents?
No, that's correct.
Right. And if you were to be asked about those documents or particular passages of it, your evidence would simply be that's what the document says.
Correct.
It's clear that what was conveyed in terms of your assessment of the advice given by Mr Hertzberg did not detract in any way from the advice that was provided by Mr Jordan, second counselled by you in December 2014, but as you've said, identified additional legal questions which didn't appear to be favourable to the new policy proposal.
Correct.
If we move then to 2016, and I ask that Exhibit 131, ending 0148, the redacted version, if it's available, be produced. Thank you. And just to provide some immediate context, the start of it's been... I know it hasn't come up yet. Exhibit 131, ending 0148, the redacted version. I understand there's no redacted version. Although on my brief perusal of the document I can't identify, I know there are some numbers which are attached to it. I should say I have seen a redacted version, although what it does is makes all the type black. So it's hard to see what...
If my learned friend just doesn't go to the second page, it'll be fine.
I can't avoid that. Can I speak about the document in broad terms then?
But those are office numbers, aren't they? Which are unlikely still to be current, you'd think, given the usual changes. And mobile numbers are a bit different. You know if you've still got the same work number as you had in 2016, Ms Pulford?
I believe I have the same work number.
The same work number?
Yes.
Okay.
Well, I'll deal with it as best I can.
Do you want to put a physical copy of the document in front of Ms Pulford? You may just have to work off it, and for the moment the document won't be available until we've got a redacted one.
Yes. Speaking broadly, firstly, this is a lengthy email trail, although you only appear to have one page.
Correct, and this is the email of 5th July, and what you've shown me is the email of 4th July, so I think this is a later version of the document. you.
Ms Pulford, can you confirm that the number in the top right corner is DSS.5003.0001.0148?
Yes.
All right. And it runs for a number of pages? And the email at the front, that is the one on the front page, is from Kristen, Kristin Lumley.
It at least can be brought up, surely. That can be on the screen while you're talking.
Yes.
Just the first page.
Yes, thank you. If the top part of that first email could be brought up. Thank you. The date of the email is 4 July 2016. There are various attachments to it. One is unnamed, one is an attachment A, customer contact letter, hyphen staff assisted, final, and another unnamed attachment. Do you recall in your preparation for evidence whether you saw those attachments?
I identified those attachments and provided them on request from my solicitors, but I didn't read them myself.
All right. It may be that no one's read them because I don't know that they have been produced, but if it becomes significant, they can be.
I think that might be significant, actually,
Yes.
because I think you need to see them to understand what the advice was given in respect of.
Yes. There is
I happen to know a notice went out asking for them.
Oh yes, they've been the subject of a notice for quite some time. I can't enlighten the Commission about why they are not here, but broadly, Ms Pulford, do you recall the topic of the 10% recovery fee and whether it could be applied in the online environment that was the proposal?
I don't have an independent recollection, but I have reviewed documents which go to that, yes.
By this point in time, 4 July 2016, this was 4 days into the operation of the first online iteration of the Robodebt scheme. You accept that?
I accept that.
That is, the scheme was underway at the point that this discussion was occurring. Mm-hmm. And if you go to the last page of the document, it seems that the discussion started, at least in this email trail, in an email between a person called Danny Scott and a Michelle Guerin, Guerin, to which others were copied, on 30 September 2015.
Yes.
And it had continued, it seems, for about 9 months or a little more, through to the 4th of July 2016. Mm. And the topic was, as you can see from the very last email there, which has helpfully been brought up by a skillful operator, that within the Department of Human Services, and we can see that by reference to the email addresses at the top, the question was the application of the recovery fee when the customer is online and has been presented with a debt outcome, and the consideration of whether it is necessary to apply the recovery fee given the assumption that it is to offset an administrative cost on recovery, but where the customer arranges their own action online, there's no administrative effort, but the recovery is still applied. And so the question asked was that it was a recovery fee, apparently driven by a legislative requirement, driven by the Department of Social Services, and DHS does not receive any funding derived by its application. if there was to be a change to the recovery fee, should DSS be approached? That was the context in which this conversation started.
Yes.
Firstly, you're aware of the concept of the recovery fee or the penalty fee provided by Section 122 capital B of the Social
1228
Security Act?
capital B.
Yes.
Yes.
Sorry, 1228, you're quite right. And it was part of the information to which the Commissioner drew your attention in the earlier email trail.
Yes.
Yes, all right. Familiar with as you are with the provision, was the understanding here correct that the recovery fee didn't go in terms of funding to DHS but went in terms of funding to DSS?
I don't know whether funding raised by the provision relates to late payment penalty, and I don't know whether funding raised by that went.
Right. Are you able to comment on the assumption that the fee was to offset administrative costs in relation to recovery action?
No, I can't comment on that.
And that's essentially because you're concerned with the interpretation and application of the Social Security law and the particular factual circumstances that it applies, rather than any broader policy implications for the department.
Correct.
We can see if we go to the top of the document, and only the first 3 paragraphs could be called out, and you have the document there before you, Ms Pulford, that the ultimate response from Ms Guerin was that DSS should be approached to seek guidance and endorsement for refinements or adjustments of the application of the recovery fee.
I'm sorry, Mr Gregory, are you asking me to confirm that that's what the document says?
Yes.
I think so, yes.
It's been helpfully called out, that is the passage at the top of page ending 0158. And you'll just see the last line there, that really this was the introduction to referring the question of the recovery fee to DSS for consideration.
Right, yes.
Right. Do you have 0158 on the paper copy in front of you?
Yes, yes, I do.
It should just be about the 3rd paragraph from the top there.
Yes, I see that, thank you.
Thank you. If I can take you to the page ending 0157, it is the previous page. Again, this appears to be an email discussion within the Department of Human Services with a number of recipients following a discussion on 30 September 2015 where the assumption on the previous page seems to have been corrected, that the recovery fee is essentially a legislative instrument aimed to encourage compliance rather than an offset for an administrative action. Can you see that at the bottom of page 157?
157, apologies. Yes, I see that.
And although you weren't aware of it, whatever the application of the policy was, section 1228 capital B was in its own terms.
Yes.
If you go to the bottom of page 0156, you'll see that a Mr Ryman sends Ms Dalton an email. Mr Ryman was in the Department of Human Services on 1 October 2015, where he effectively engages with the Department of Social Services through Ms Dalton, seeking clarification about the application of the debt recovery fee in the context of the compliance intervention, and has a series of questions which are addressed there.
Yes.
The options that he identified were expressed this way: depending on what is possible under legislation/policy, we are considering three options. One, the automatic application of the recovery fee to any debts, as this income is from personal exertion. Two, the application of the recovery fee following customer responding to a couple of questions to determine whether there was a reasonable excuse for not correctly reporting the income. And three, utilising the recovery fee as a lever to influence customers to enter into a recovery arrangement at that point. And he gave an example where a customer might agree to recovery arrangements and the fee wouldn't be applied, but if they weren't willing or unable to enter into a recovery arrangement, the fee would be applied. And he indicated a tight deadline with ICT, which you understood to be information computer technology,
Yes.
and the need for programs and measures for the proposed online compliance program to be established and
Yes.
implemented.
Yes, system build.
System building, yes. And if we just go over to page 0155, you'll see a further email from Mr Ryman on 15 October 2015 that the earned income matching brackets PAYG brackets element of the strengthening the integrity of welfare payments, we currently have an ICT delivery date of June 2016. And you understood from your earlier evidence, or I understood from your earlier evidence, that the budget measure which was being considered early in 2015 was the strengthening the integrity of welfare payments budget measure to which that refers.
Yes, yes.
Right. Now, some discussion occurred preceding that notification of the ICT deadline in respect of what changes might need to be made. And if you go over to the top of page 156, this is an email 8 October before the one you just referred to, there is a reference to a further discussion, and this is a discussion between persons within the Department of Human Services, that the recovery fee is actually described in the legislation as the additional 10% penalty for understatement, etc., of income. You can, and again, that's been very helpfully called out. You can see that there, the top of page 0156.
Yes, I see that.
There's a highlighted passage there which is included in the paragraph commencing as policy owners. DSS may have assessed this and agree with the application in these circumstances, and the suggested application is in accordance with the intent of the legislation. You can see, of course, how the discussion is developing within DHS in its transfer to the Department of Social Services.
Yes.
But at least at that point, the discussion in DHS identified a change in the application of methodology, the Guide to Social Security Policy, as per link below. See that?
Yes.
In terms of identifying whether someone, whether it applied only after contact or in respect of the non or under declaration of income. Those amendments to the Guide to the Social Security Policy were then the subject of some emails which appear to extend through to June 2016. If you just flick over the preceding pages until you get to page 152. You'll you'll see that the email trail about decision makers referred to in the guidelines and other documents and the need to have amendments by the 1st of July 2016 was imminent. And we then reach a point in time where on page 0152, Ms Lumley at DSS sends an email to Mr Ryman at DHS, copying in various persons, including Ms Dalton from DSS. And that was, I think I said, dated 20 June 2016. You can see that?
Yes.
And even at this very late point in terms of the need to have this resolved for the commencement of the program on the 1st of July, there are still discussions which are occurring about how and when the 10% recovery fee might be applied.
Yes.
Did it appear to you that this was part of the time constraints brought about in early 2015 by the budget measure, the proposal that was identified then, which carried on in terms of uncertainty about legislative change through to June 2016?
I don't now recall.
Let me put the question another way. In the sequence of emails that I took you through in early 2015, you'll recall that we reached the point where, in addition to the issue identified in the December 14 advice, additional legislative impacts of significance were identified in the development of the new policy proposal.
Yes.
And that all that could be done in the time available at that point was really to identify potential legislative problems of significance without providing meaningful advice on any of them.
Yes.
And that was because of the time constraints.
Yes.
And that by the time the budget measure occurred, that is, it was announced in May 2015, those issues remained unresolved, that is, not the subject of detailed legal advice to your knowledge.
To my knowledge, yes.
And we see one aspect of a question about legislative change or legislative impact or the application of existing legislation and uncertainty of it, which appeared to be unresolved even up to late June 2016.
Yes.
And the discussion here, of course, has reached Ms Lumley, and it occurs between both departments. I should say I'm at the page which has been called out, 0152. And there's a discussion which had occurred the previous Friday with Tennille, who was going to send through a copy of a letter that would be sent to the recipients picked up through the PAYG measure. That hadn't occurred apparently, and Mr Ryman was asked to send through the letter in her place. I'll come back to the content of those letters shortly, but what is identified in the final paragraph is that there was an email that had been received from Jonica Burge within DHS response to the Ombudsman issue of interest questions concerning online compliance platform for DSS. Did you have any knowledge of any Ombudsman's interest in the program at this point in time?
I don't recall.
Thank you. It appears we have the redacted document. The conclusion to the paragraph is an identification of an obvious point, that is, online engagement is preferred, that is preferred by DHS with an online compliance program. But DSS, at least Ms Lumley, wanted to confirm that the letter would provide an alternative contact method for those that did not want to or could not engage online. You see that?
I see that.
Yes. Now, having refreshed your memory about the broad question of the application of the 10% recovery fee, do you recall seeing any of the attachments to this email sequence about what the draft letter that would go to recipients in respect of, and what it might say in respect of the 10% recovery fee?
Oh, yes, I do now. I have reviewed these documents.
You have?
I have.
Okay.
I'm sorry, I said I hadn't. They were the different forms of letter for various points, depending on factual circumstances.
All right. We'll take it as far as we can without access to them. But if you go over to page 150 and we go to the email from Ms Lumley to Ms Pulford and Ms Dalton at the bottom of the page, 22 June 2016. Thank you. The question has progressed to the point where these people, that is, the three identified as parties to the email, are all within DSS.
Yes.
Right. And the email is addressed to you. I'll just give you a moment to read that.
Thank you.
If we go firstly to the first dot point, there is a reference to attachment C, which was one of the draft letters, I take it?
I believe so, having reviewed it.
Yes. And that is the streamlined and cost-effective approach, as it was described, to manage inconsistencies in income tax payment summaries. And the letter would be issued directing someone to get their MyGov account to confirm employment online. Now, if we go then to the second dot point underneath that, it seems that a different letter had been developed which was described as a staff-assisted letter which provided a phone number as an alternative contact method. Can you see that?
Yes.
Is that your recollection of viewing the attachments, that there was attachment C, a general starting point, but then there was a different category of letter which provided some additional contact information?
Having reviewed these more recently, yes, that's my recollection.
All right. And then if we go to the third dot point, which appears to be related to the first, that is the standard letter, for customers who engage online, they'll be presented with a series of questions to determine whether a recovery fee is applicable as per the current reasonable excuse policy, and that where no contact is made within a time frame, the fee is applied. You see that? Now, this really was the information that Ms Lumley had about which she was asking you to consider. The information that she had continued towards the bottom of the page in that paragraph commencing the online compliance interaction. The effect of that paragraph was to identify that the measure enabled significant increase in compliance activity and cost savings by removing the need for staff decision making. Firstly, did you understand that from the earlier documents we've seen where the figure of 900,000 interventions was identified with savings of 1.2 billion, I think it was, that was achievable only through an automated system or a semi-automated system? That's the nature of the proposal as you understood it.
I don't now recall. My review of the document indicates that probably would have been apparent.
Yes. The paragraph goes on to identify that past experience shows that if an alternative phone number is provided, a significant proportion of recipients won't engage online. Do you see that?
Yes.
Which suggests that the provision of a phone number in a letter might be counterproductive to the involvement of staff in the process.
It would suggest that, yes.
Did you become aware in 2017, about April, of an Ombudsman's report which identified deficiencies in various letters, including the failure to provide a telephone number?
My review of documents has made me aware of Ombudsman's inquiries in that time frame. I don't recall this issue being part of that, I'm sorry.
All right. But in any event, at least from the information that was conveyed to you by Ms Lumley, it appeared that her understanding was that there was a deliberate choice to funnel people, as it were, to an online process rather than to a telephone process for the online compliance measure.
That's what the email suggests.
Section 122B of the Act is then set out over the bottom of that page to the top of the next page. If that could be called out, please. Thank you. Now, as you said, it was a section you were generally familiar with at the time, and it was the topic of how this question developed and came to your attention.
Yes.
And Ms Lumley set it out in her email to you, which identifies that a 10% penalty fee is added to a debt in particular circumstances.
Correct.
Now, only part of Section 122B is reproduced here. You can see that.
Yes.
From your familiarity with it.
It's a long section.
That's right. And what is reproduced is subsection C, and subsection 1 is just summarised in the first part. Yep. And the question here is where a person refuses or fails to provide information about their income, or they knowingly or recklessly provide false or misleading information about their income. In the circumstance that when required under a provision of a social security law, they have to provide that information about their income. You see that?
Yes.
And you understood the operation of the section to be founded upon the starting point that there was a person had to be under an obligation to provide information, that is, by a provision of the social security law, they had to provide information, and in that circumstance, when they either refused or failed to do so, or they gave misleading or false information, a penalty could be applied.
Correct.
And within section 1228B sub 4, there was the discretion of the secretary to waive the fee or not apply the fee in circumstances where a person had a reasonable excuse for refusing or failing to provide the information.
Correct.
See that? That is, the circumstances granted by the section to the secretary to not apply the fee did not include the scenario where someone knowingly or recklessly provided false or misleading information when they were required to provide that information.
And did not have a reasonable excuse.
That's right. Now, do you recall that the topic of the conversation developed in a way in which there was a focus on the reasonable excuse component, which in sequence ought to have fallen after the question of whether there was a lawful obligation to pay?
Having reviewed the documents, yes, the focus of the questions that were asked of legal services were focused on reasonable excuse.
And missed that foundational point that there had to be a requirement on the person to provide income information under a provision of the Social Security law before the 10% fee could be applied.
Yes.
And was it...
Just on that though, the attachment C that they gave you appears from the text on page 0149. It's described there as a notice under paragraph 68(2)(b) of the Social Security Administration Act. In other words, you'd know that section, I imagine. It's a notice given by the Secretary.
Yes.
So you seem to have been given the premise that that's what people would be getting, a notice from the Secretary. Is that correct?
Yes, that's what I take from the documents.
Did you ever see the letter that actually went out to recipients?
I don't recall whether I did or didn't.
All right. Hence my interest in these attachments.
Yes.
Gregory?
Yes. I will be able to take it a little further, but ultimately we will require the attachments to answer the question.
Commissioner, can I just indicate that the email in its native form with the attachments has been located. It's a rather big document in terms of its size. I don't have any capacity to print anything or do anything, but can I just indicate to you that we're doing our very best to ensure that the Commission's team has it.
Thank you very much.
The reason it wasn't produced previously is it hasn't fallen within the scope of the requests because it refers to an advice that is in between the two advices that were the subject of the requests.
There has been a specific request for the attachments.
At least to my client, from what I know, I can't speak on behalf of Ms Hogan-Doran's client, of course, but that may be one reason why this is a little clunkier than you would appreciate, Commissioner.
Thank you.
Commissioner, I wasn't aware of the inquiry. I've been making inquiries while the examination has been progressing. We've also relocated the original native file with the attachments, and I understand that they are being emailed to the Office of Solicitors Assisting, assuming there's no size inhibition. I don't know what's gone wrong. I'll find out and report.
All right. But what I'm deeply interested in is attachment C, the letter that was given for the purposes of the advice.
Thank you, Commissioner.
Thank you.
And I can inform you, Commissioner, that I'm looking at it now. So it does exist, and it'll all be here. But it's a rather big document because what happens is there's a number of different emails that are attached. So
Okay.
I think in the process where people pull all the emails apart, these things get lost. But
Can you actually look at attachment C, the letter?
I certainly can. I hope I'm not giving evidence, but yes, I can see it.
And does it contain something that suggests a notice from the Secretary of Social Security? Or
It appears to me to be a guidance note.
a guidance note? Or perhaps we'll wait till we actually get it.
And at danger of me giving evidence as well, which then will get me in trouble, no doubt.
Thanks, Mr O'Neill.
Mate, please.
Commissioner, on my record, DSS 5003 0001 0185 is attachment C. I don't know if that brings it up in any way.
Well, one way or another, we'll get to it, I expect, but
Yes.
if you want to go on.
I can go on, Commissioner. If we just return then back to that document at page 0151 and pull out the middle portion commencing DHS have requested down to the end of the email. Thank you, yes. Ms Pulford, again, this forms part of the information conveyed to you by Ms Lumley. And the question that appears to have been asked by DHS was related to the amendment of the Social Security Guide,
Yes.
which we've addressed in the context of the online compliance intervention. But it appears also that the Ombudsman had raised the following issues as per an attached email from DHS. And the question was about whether DHS had sought any internal or external legal advice or instructions/comment from DSS about this change in approach, particularly whether automatic application of the REC in the absence of contact from a potential debtor will satisfy the reasonable excuse provision in section 1228 capital B subsection 4, and there was a request to provide that advice. So that was the background as it was given to you. To your knowledge, firstly, had your team or anyone in it given advice previously about the debt recovery fee within, as it applied to the online compliance intervention?
I have no recollection, so I really couldn't say yes or no.
And you haven't seen any document in your preparation for this which suggests that might have been the case?
Nothing prior to this.
No. The question as it was asked of you related to whether the process satisfied the reasonable excuse provision.
Yes.
That is, it moved beyond the question of the requirement under a provision of a social security law to provide information and addressed what may follow, assuming that existed and a person failed to provide it or provided misleading information. Sorry, failed to provide the information.
Okay, yes.
All right. If you go then, if the document can be taken to page 150, there are rather two emails in the top half of the page. Thank you. The first was 27 June at about 9 o'clock in the morning from Ms Lumley saying, we've got a meeting this afternoon with the DSS. Could you give me a time frame on the advice? The usual question asked of people given the task of providing advice. And then a follow-up on 27 June, about half an hour later, which indicated additional information had been received from DHS and they've clarified a couple of things about the draft letters.
Yes.
Attachment C is the default letter that would be issued to customers, and there are exceptions relating to those who have an identified vulnerability. And then an alternative contact has not been provided as it was the intent for customers to confirm or update income in the online environment. And to achieve that strategy, you don't offer alternative contact options in the first instance. But if someone engaged in the online process, there might be additional contact information provided at that point. Mm-hmm. That was the information conveyed as Ms Lumley understood it from DHS.
Yes.
Right. And then we come over to the relevant parts of the advice which are contained commencing on page 0148 and continuing over the page. And this is your response. On the 1st of July 2016, it's an advice from Ms Ulrich, 1 July 2016 to Ms Lumley, and you and Ms Dalton are copied into it.
Yes.
And to confirm, was Ms Ulrich a lawyer within the team?
She was.
And she, like Mr Jordan, in December 2014, had done a draft for you to second counsel. I see some uncertainty. Can we go to page 149 towards the bottom? There is a couple of sentences which contain redacted portions at the end of the page which provide, this has been cleared by Anne Pulford, principal lawyer. You see that?
I see that, yes.
And Ms Ulrich was directing inquiries about the advice to you. That indicates, doesn't it, that you had gone through that second counselling process?
Yes.
It was described earlier, although in this email it's described as a clearing process. It means the same thing.
Yes, correct.
Looked at the email and satisfied yourself that it was legally sound and responded to the question.
Correct.
All right.
Mr Gregory, it may not be apparent to you, but there are actually red parts of that email.
Yes, there are. They are not highlighted because I think they are lost in the redaction process.
But this is still a draft advice, isn't it? Not the final?
Yes, Commissioner.
Yes. The draft, if we start with the bottom or the lower part of page 0148, involved the restatement of the question on, yes, the first page towards the bottom, the draft advice, yes.
Thank you, yes.
Involves a restatement of the question you were asked about the reasonable excuse provision. There was a note in the next paragraph that it was substantially different to the current approach, but that the online intervention process would still satisfy section 1228B of the Act.
Yes.
You then go on to provide explanations for that. But if we go over to the, reasons are provided in support of the opinion in its short term, which continue over the page. And if we look at the first paragraph, concluding letter C, just a little bit above, thank you very much. The passages in red for your Assistance Commissioner.
I've got a copy.
Oh, thank you. Can I get to the critical part? It is the sentence, if the person receives the letter at attachment C, brackets, a notice under paragraph 68(2)(b) of the Social Security Administration Act, brackets, and confirms their employment income, there is no scope for a penalty amount to apply as the debt has not arisen in circumstances satisfying 1228 capital B subsection 1C of the Act. You see that? Now, can you convey why that was so?
Because the principal trigger for the penalty amount in 1228B was the failure to appropriately report income.
And the focus of this advice was what happened in the online environment at some point after a person had applied for income benefits, received income benefits,
Yes.
and a retrospective data matching approach had occurred. That is, the letter wasn't being sent in respect of what happened last week or the week before.
Correct.
And so the question was confined, or the explanation was confined to arise in circumstances where a person engaged or did not engage with the online letter.
Yes.
And at that point in time, if someone received a letter and responded, even if it was to confirm that their employment income contained a discrepancy, the obligation to provide that information only arose at the time they received the letter.
That is what this draft provides, yes.
That's what this draft provides. And The obligation arose in terms of 1228B because the requirement under social security law was imposed in a letter which was sent pursuant to the notice provision under 68 of the Social Security Administration Act.
Yes. Although this says that this is premised on the fact the notice under 68(2)B is attachment C.
That's right, the form of the draft letter. So even where a debt might validly exist, where a person engaged in response to the letter, which was effectively a notice under section 68, they didn't fail to do anything within the terms of 1228B, sufficient to trigger the 10% recovery.
Based on this draft, correct.
Yes. And as you say, at the passage below that, which commences, if a debt does arise for this person, and so not the called out passage, but the passage immediately below it. If a debt does arise for this person, yes, thank you, it has arisen because the person confirmed their correct income for the relevant year. That's right?
Yes.
Now, when you say the debt has arisen because they confirmed their correct income for the relevant year, you were saying, you were again saying something consistent with the 2014 advice, that it was the person's confirmation of their fortnightly income which proved the overpayment, rather than the average which was advanced. That's right?
Yes, correct.
The alternative proposition, that is, the person received the letter and did not do anything, and the Secretary applied the updated income information, the penalty amount would apply because the person failed to provide information when they were required under a provision of a social security law. Now, there you are referring, I take it, to the fact that irrespective of what your 2014 advice was, assuming the person received the notice requiring them to provide information, if they didn't provide information and, as required, and a debt amount was raised by the Secretary's decision, that would satisfy the provision.
That is what this draft assumes, yes.
That's what the draft assumes. Can I take you down to the last paragraph, commencing finally, yes. And you identified a deficiency in attachment C, in that it was not explicit about the consequences of failing to confirm employment income.
Yes.
That is, that a 10% penalty would be added to the debt.
Yes.
And given that the 10% penalty fee was said in earlier emails to be an incentive for someone to report accurately and therefore provide information, it would be difficult for that incentive to exist if it wasn't identified explicitly.
Yes.
If we go back then to page 0148, at the middle of the page, Ms Ulrich says to Ms Lowe that we would, that is you and her, would be happy to finalise the draft on Monday subject to any views she had. Now, the red passages contained in your copy, which aren't apparent on the redacted version, indicate that Ms Lumley were inserts by Ms Lumley in the sequence and indicated that she did have significant questions about the advice.
Yes.
And those questions formed part of a challenge to the underlying reasoning of the advice. Would you agree with that?
I am not closely familiar with the comments Ms Lumley has written.
Her comments, if you just read them through, do you agree with me? They are directed really to the fact that if a debt exists ultimately, it was because the person failed to accurately inform Centrelink of their income at the time they received the benefit. That is, there's a distinction between her comments generally and the nature of your advice about at what point the obligation arose and what would constitute a reasonable excuse. She was directed back in time, or directing things back in time to when the benefit was received, and your advice was addressing the question of engagement with the online process at a much later point.
Yes, and I think in broad terms that is a fair characterisation of what Ms Lumley was saying.
Do you recall that yourself and Ms Ulrich met with Ms Lumley on the following Monday?
I don't recall.
At least at the top of page 1, we can see that Ms Lumley has replied to Ms Ulrich and said that she did have some concerns which were highlighted in red below, and you've been able to see those on the hard copy of the document before you. And she goes on to explain some more about that in the context of what she puts over the page.
Yes.
If we could turn then to a document ending 1027. Exhibit 89. It is a redacted document. This is the final advice following what may have been a meeting on the Monday.
Thank you.
And because it's redacted, because it's the final advice, it doesn't contain variations in colour in font. And again, in preparation for your evidence, you've reviewed the final advice that was provided on the issue by yourself and Ms Ulrich.
Yes, I have. Although these documents were not the subject of the notice that I received to give a statement, and so I have not focused as closely on these as I have on other documents.
Very well. In case I spoke too quickly, it's Exhibit 89, DSS.5006.0001.1027. I understand there's no redacted version. The only telephone numbers appear on the second page. That's quick work. Firstly, Ms Pulford, you can confirm that this is the final version of the advice?
Based on
Based on your review of the documents?
Thank you, yes.
Yes. And I wanted to take you down to the third paragraph under the heading advice on the first page. which commences a useful example. And again, you'll see that this paragraph had some similarity to a paragraph in the draft to which I took you. And the particular sentence I wish to highlight for your attention commences 5 lines from the bottom. We understand that at all times. You can see that sentence?
Yes, I see that sentence.
We understand that at all times the person is subject to a notice under subsection 68(2) of the Social Security Administration Act 1999 to inform the department if a change of circumstances occurs. You see that?
Yes.
Now, having moved from the point where you understood attachment C, the general letter to be sent to recipients in the online environment, was a notice under section 68 of the Social Security Administration Act, but that it needed to be explicit about the 10% recovery fee. That was on the Friday. On the Monday, the advice has now moulded somewhat to a broader statement about an ongoing obligation under section 68.
Yes, with a slight clarification, our advice was that the attachment C needed to be more specific, that it was a notice under 68(2), and that could have a range of consequences. A failure to comply with the notice could have a range of consequences, not limited to the late payment penalty.
I see. So the point that was raised by Ms Lumley in red, where she said she had some concerns about the draft advice, and there was the meeting foreshadowed on the Monday, and her concerns were directed to a point in time when a person received a social security benefit and whether the debt provision, the 10% debt recovery fee, arose at that time because a person was under an obligation, compared to your advice, which focused on the point in time at which a person did or did not engage with an online compliance measure.
Yes.
Those 2 times became the one time or all times for the purpose of this sentence.
Correct, by virtue of the fact that every social security recipient receives a 68(2) notice to advise of any changes of circumstances.
Right. That is, at the time they receive the benefit.
And indeed when they make their claim.
Okay. But I had those back to front. At the time they make their claim, which applies during the period that they receive the benefit?
Yes. Yes, correct, both.
But a person who receives a benefit is also under an obligation to report fortnightly income because there's an income threshold for these category of payments.
Correct.
Or this category of payments, yes. And the language that was used in that sentence covered Ms Lumley's concerns and the focus of your advice about the question of the timing of the online intervention engagement.
Yes, it concerned both.
All right. Well, given your 2014 advice, where you said that the allegation of a debt, that is, the averaging of income, might not be accurate about what a person in fact received during a fortnightly period, were you concerned about the question of whether an alleged debt for someone who didn't engage might in fact not reveal a failure to provide information as required back at the time the benefit was received?
I think the documents indicate that the advice was sought on the basis that the debt was valid.
Well, matters had moved on, hadn't they, from 2014 to the point where just a DHS proposal existed to something that was actually implemented on the Friday of the draft advice and was underway at the time of the 5 July 2016 final advice. This was a scheme in full operation.
Yes.
It might not have been full operation in terms of its size, but certainly its implementation was operational. You understood that?
Yes, the documents indicate that I would have understood that.
All right. Where did you move then from the position you expressed in December 2014 to an assumption that the debt would be valid, that is, accurate?
I don't think I can answer that question.
Is that because you never agreed with the assumption?
I don't have a clear recollection of the precise events occurring.
But what you must have appreciated by this point in time was that fundamentally online averaging was used to identify what was said to be a discrepancy and a notice being sent, attachment C, the terms of which were still being settled, which was used to calculate a potential debt, ultimately. So nothing had really changed in a factual sense or in a legal framework sense from what you understood the case to be for the purpose of the 2014 advice.
Correct.
What's not discussed in any of the emails that we've gone through between September 2015, appreciating, of course, that you weren't party to the DHS emails until they hit the DSS parties in 2016, but what's not expressed is that the underlying legal flaw still existed in addition to the flaws identified by Mr. Hertzberg. That's right, isn't it?
Yes, that's right.
Can you explain why that wasn't agitated by the legal team tasked to identify significant flaws, far more significant than whether the penalty applied?
I object to that. I object, Commissioner. I'm not sure that assumption's been made good.
Sorry, which assumption?
The assumption of the question, the premise of the question hasn't been set to the level at which it's just been expressed.
Well, I think the premise is that they started from the position that the averaged income didn't give rise to a debt and somehow, well, anyway, I'll let you re-articulate it.
Yes. I'll address what I think is the assumption. You would agree with me, the issue identified by you in December 2017 in conjunction with Mr. Jordan and the issues identified with Mr. Hertzberg in 2015 in respect of the new policy proposal were far more significant than whether the 10% penalty fee applied or recovery fee applied. They went to the heart of the validity of the scheme.
Yes.
And throughout all of this email trail that we get to after the scheme is up and running, within days of its starting, there's no mention of the underlying legislative questions that go to the validity of the scheme.
There is no mention.
And to your recollection, you can't explain it?
I don't have an express memory as to why that, I don't remember why that wouldn't have been mentioned, but a government decision had been made at that point. And the internal legal area continuing to query the legal underpinnings of the decision, which had been raised and presumably taken into account when the decision was taken to proceed, I don't think would have been regarded as helpful by our client areas.
Regarded as helpful to whom?
To continuing the business of the department and implementing government policy.
You did appreciate, though, that although the advice might be unhelpful to the business aspects of the department, that is the recovery of money, and might be unhelpful to government policy, to your mind, the advice was still valid. The scheme was legally flawed.
I have no recollection of thinking anything differently at the time.
Can you describe then the dynamics that existed in terms of how the implementation of government policy and the establishment of the scheme, to your experience, outweighed the legal questions which you were personally aware of and understood to have been raised?
Well, the two are in conflict.
Yes.
But to my mind, the role of the internal area was to make clear risks, which government then decides, essentially. They take into account the risks, they decide how they're going to proceed.
In practical terms, you advise and someone else decides what to do with the advice.
Correct.
And once that decision's made, you're not engaged to advise again, and the scope of your advice role has concluded.
Correct.
One of the questions into which the Commission has to inquire is what measures might be taken to ensure that any failures of administration which are identified in the course of the inquiry don't occur in the future. From the evidence you've given so far, it would seem that part of the failures up to this point are the fact that legal advice was disregarded or ignored or disagreed with, and to your knowledge, without any opposing legal advice. Would that be right?
Well, I don't have complete knowledge of the advice that may have been available to decision makers, which may have come from other sources.
All right. Reflecting then on what has happened up to this point, can you identify anything that might have led to a different outcome following your advice in 2014, other than the implementation of the scheme?
I'm sorry, can you...
That is, how does your advice in 2014 not get the traction that it would seem to have been given early on? Can you identify from your experience in the department blockages in the system which might have led to that?
From my experience in the department, without knowing the ins and outs of this particular issue,
Yes.
there are a range of risks which decision makers are taking into account and potential benefits that they see in making a decision as to how government will proceed. Legal risk is certainly one of those factors, but there are other risks and presumably other government benefits that are perceived. So I don't think I can identify a specific failure in this instance.
Just while we are on that exhibit, if we could go to the second page, please, page 1028. It is the third paragraph. In case it hasn't been redacted, that's all that needs to be pulled up. The qualification you gave in your evidence earlier, Ms. Pulford, was that what you said on the first page, to which I drew your attention to, was subject to this particular qualification. Is that right? Finally, we recommend the letter sent to recipients is explicit about the consequences in relation to the 10% fee.
In relation to the 10% and potential other consequences, yes.
You say, or rather, Ms Ulrich, with your clearance, said we would be happy to work with you on drafting parts of the letter to make that clear. I take it that the letter still didn't make it clear as of for July 2016?
That is what the document
At
indicates.
least according to that?
Yes,
Although there may have been some updates over the weekend when the scheme was implemented.
there may be.
Commissioner, I have 4 copies. I'm not sure where they've come from, but I'm told that they are attachment C. One for the witness and 2 for you.
Thank you.
All right, I think that'll be Exhibit 136.
The document identifier is DSS.5003.0001.0191.
Have you given one to Ms Pulford?
Yes, Ms Pulford has one. Ms Pulford, as I read it, I see at the bottom of page 1 under the heading What You Need to Know, the last sentence says a 10% recovery fee may be added to the debt amount. You would be advised of the outcome in writing. Is that the version on which you gave the advice that we've just referred to?
I don't believe I can confirm that at this point because I didn't look very closely at these documents in preparing to give evidence.
If it was, you wouldn't really regard that as a notice from the Secretary under Section 68, would you?
Correct, Commissioner. I would expect more detail about the legal basis for the notice.
Thank you.
Just on that point, Ms Pulford, you're familiar with Section 71 of the Social Security Administration Act that says that notices within that section are to be specifically identified as notices sent pursuant to those sections.
Yes.
And even though a failure to do so doesn't invalidate the notice, that is a clear requirement under Section 71 of the Administration Act in respect of a Section 68 notice.
Yes.
Yes. All right. And so it may well have been the version of the letter to which you said that you recommend that the letter sent to recipients is explicit about the consequences of not responding to the letter, which is not a concept incorporated in the brief reference at the bottom of page 1
Yes.
of 136. Right. Yes, thank you. Can I turn now to another exhibit, but another exhibit, but on the same topic of the recovery fee. It is Exhibit 126, ending 0363. I might just have a moment. This is an email trail which ends, as we can see, on Friday, 7 April 2017, and it exists in its final form between two persons who are employed at DHS, Maris Stipniks, I hope I pronounced that correctly, STIPNIEKS, and Jason Ryman. But if we go to page 0365, right at the bottom, we can see the email of 5 July 2016 from Ms Ulrich to Ms Lumley, to which you are copied, which relates to the question of the 10% recovery fee, and thereafter follows the final version of the advice that we've just been through. All right. Going back to page 0364, and starting at the top, there is an email from Annette Musolino, 13 February 2017, to Mr Stepniks, and an email underneath that from Mr Grinzel Jones to Ms Musolino, to which you have been copied. You see that?
Yes.
All right. Now, if we go down to the email below the one to which you were copied, it appears to be an email by you which is a draft response to some particular point on the 9th of February 2017. It is addressed to Janine Richards. Firstly, who is that?
She was then Chief Counsel within DSS Legal.
That is, her position oversaw all of the legal teams that you identified earlier.
Yes.
Was there a more senior person in the legal stream within DSS than Ms Richards?
No.
And in terms of her employment band, where did she fall?
She was an SES band 2.
The email trail does not include it, but the draft of the response to Kath is that. Which Kath is that?
I'm not sure. There
Might be Catherine Dalton.
It might be, although this is a very senior level of advice to be being provided to Catherine Dalton and EL2.
Right. That is, you would hardly go to the Chief Legal Counsel to have an advice for someone at your level or about your level.
Yes.
So it doesn't sound like it is Ms Dalton.
I wouldn't have expected so.
Do you recall who else it may have been? All right. The introduction, though, indicates that it's a draft response to Kath. We'll use second counsel. The request for the second counsel was, of course, to Ms Richards, who you've said was the Chief General Counsel.
Yes.
And the question asked by Kath was to consider whether there were legal arguments supporting not imposing a 10% penalty upon the understatement of income of most debtors whose debts arise from recent data matching activity by DHS, rather than the provision of false or misleading information. You say in the draft, in short, it is arguable that a penalty does not apply to these circumstances unless it is established that the person has information that indicated their income from personal exertion reported was too low and chose to fail to advise DHS. You see that?
I see that. There was a Kath Halbert who was more senior in the department at the time.
Thank you. You refer in this advice to the earlier advice. It is the one provided, as we identified, 5 July 2016. Do you recall that in the circumstances in February 2017 in which you were asked for this advice?
I don't, I'm sorry.
Were you aware of increased publicity in the media about the Robodebt scheme in December 2016 and January 2017?
I don't now have a recollection of it.
Were you aware within your department of an own motion investigation initiated by the Commonwealth Ombudsman into the scheme in about January or February 2017?
In my review of documents for the purposes of this review, I saw documents to that effect, yes.
But again, you have no independent recollection of
No.
those events? And I take it from that you have no independent recollection of why you were being asked again about whether there were arguments against the imposition of the 10% penalty?
No, I don't know, I'm sorry.
Ms
Even-
Pulford, we've gone from the position where they were so keen to charge a penalty that everybody was prepared to proceed on the basis of an assumption that a discrepancy with the ATO PAYG data and what was reported meant that there'd been a failure to report properly and that a penalty should be imposed, to this sudden, is there a way we can avoid charging penalties? You really don't remember anything about why there was this turnaround?
I'm sorry, Commissioner, I really don't.
All right, thank you.
In any event, you sought the second counsel of the Chief Counsel within DSS to provide a response to Kath, and you can't recall the circumstances in which that was required, but the arguments in favour of not applying the 10% penalty were identified by you.
Yes.
And wherever it emanated, you were copied into an email just above this on 13 February 2017 from a Mr Grinsell Jones to Annette Musolino. Firstly, who is Mr Grinsell Jones?
Mr Grinsell Jones was then the Deputy Chief Counsel. He was an SES Band 1.
In the Department of Social Services?
Yes, in the legal branch. He was my direct manager.
Your Director Manager. And what you can see from this document is that he sends the email to Ms Musolino, copying you in. Annette, as discussed this morning, please see our draft below. Happy for any comments or to discuss. And did you understand at that point that Ms Musolino was the Chief Legal Counsel for DHS?
Yes, I did.
And that whatever generated this question about whether the 10% penalty maybe shouldn't be applied, it was being discussed at the highest legal level within both departments in a collaborative sense.
It would appear so from the documents, yes.
Ms Musolino's response is at the top to Mr Stipnieks. Maris, can you work with Alan on this? An indication that he was to work with the 2IC and the DSS legal team about the question.
Yes.
And what we see over the following page is the response from Mr Stipnieks to you, copying in the Chief Legal Counsel from DHS and the Deputy from your office, where he says, Anne, I refer to our recent telephone discussion concerning the matter. Do you recall when you received a call from Mr Stipneeks about this question which was being discussed at that high level?
No, I don't.
What do you recall about the effect of what he put in writing here following that discussion that you can't recall?
The effect, I'm sorry, could you clarify the question, please?
He was really pushing back on the suggestion that there might be arguments against the imposition of the penalty.
Yes,
Pushing back strongly.
yes.
That would have been conveyed to you in the telephone call, wouldn't it?
Based on the documents, yes, I believe so.
Can I just raise another issue? The penalty was being applied to past recipients of benefit, isn't it? Not just current?
To be honest, I don't think I know that, Commissioner.
All right. It couldn't be, though, could it? Because Section 128B only provides for notices to be given to somebody to whom a social security payment is being paid. So it would have to be solely on the basis that back at the very beginning when they got it, they failed to notify. So that's your line, I suppose. Your second line is there's some continuing notice that has effect even after somebody's ceased to obtain benefit. Is that the thrust of it?
Yes, that's correct, Commissioner. The notices are regarded as ongoing.
All right. Okay, thank you.
Did you understand from at least the email that's before you that the push to maintain the recovery fee, that is the arguments in favour of the recovery fee, was coming from the Department of Human Services, that is Ms Musolino and Mr Stepneeks, not the Department of Social Services?
That seems to be the way the email reads, yes.
You said that you had, in preparation for giving your evidence, reviewed documents which indicated an Ombudsman's investigation in early 2017.
Yes.
Do you recall any relationship between that investigation in respect of the 10% recovery fee and the opinions at this point in time?
No, I don't recall a relationship.
Do you recall events following this where there was an abandonment of the 10% recovery fee by DHS?
No, I'm sorry, I don't.
If that occurred, you haven't seen any record of it? Can't recall seeing a record of it?
I don't believe that the review of documents has caused a record of that to become apparent.
The end of the email from Mr Stipneeks indicates he's happy to discuss further if that would assist. That is, assist what?
I don't now recall, but I would have read that at this stage as being, in case his reasoning as to why he suggested that the approach I had suggested was incorrect was not sufficiently apparent from the email.
Do you recall whether there was any further emails or follow-up?
No, I don't recall.
Look, can I just go back to the train of thought I had before and ask you this? In your discussions with Ms Lumley, where you moved from the position that the letter sent out to a customer was a notice under Section 68 to the original advice or whatever a recipient got at the start was Section 68, was it because the notion that the notification to the customer at the time of the online compliance program being given effect in relation to them couldn't be a 68 notice if it was somebody who was no longer on benefit. Did that make sense? In other words, if you took your original position that it was when the customer was notified of the PAYG discrepancy that they got a 68 notice, it couldn't work for somebody who was no longer on benefit.
I don't recall that being a driver for that view, but that doesn't seem unreasonable.
All right, thank you. Sorry, Mr Gregory, I was just working that through.
Not at all, Commissioner. That concluded the extent to which I proposed to cross-examine in respect of that document. I was moving on to the 2017 year more generally,
Time
rather
for
than
lunch,
in
you think?
relation to that, yes.
All right. 2:30 suit everybody?
Thank you, Commissioner.
Thank you. 2:30 it is.
All rise. The Royal Commission stands adjourned until 2:30 p.m. Royal Commission is now in session. Please be seated.
Yes, Mr Gregory. By the 8th week of hearings, I think you'll have it.
Maybe. I've delegated the job to my junior. Ms Pulford, before the lunch break we concluded the topic of the 10% recovery fee, which took us into April 2017. Can I go back to January 2017 and start with a different topic, and this is the Ombudsman's inquiries and advices you gave in that context. If Exhibit 101, DSS.8001.0001.0346 could be brought up on the screen. Ms Pulford, this is an email dated 13 January 2017 from Melanie Metz to you, copying Ronan O'Donnell. Firstly, who is Melanie Metz?
Melanie Metz was then a principal lawyer in the same team as I was.
Right. And had Ms Metz been in that team for the preceding 18 months? 2 years?
Of that order, I believe, yes.
Do you know if she was around at the time that the December 2014 advice was given?
I'm pretty confident she wasn't.
Was not?
Yes.
On Friday 13 January she sends to you this email. It's short, but there are a number of attachments, and she simply asks, or notes rather, that there have been a number of urgent requests for advice on Centrelink debt this week. Ronan and I have handled it, and I only made one silly mistake that I know of anyway. Now, Ronan, was he also in the team?
Yes.
And at what level?
Ronan was a lawyer.
Okay. From the attachments we can get some idea of what the requests for advice were on Centrelink debt during that week. Do you recall, having looked at this note at least, what was happening in that week that might have led to a lot of urgent requests for advice on Centrelink debt?
To be honest, no, I don't.
Do you remember that there was a significant media interest in the question of the Robodebt scheme?
I remember a range of media interest in the scheme, not specifically for this particular time frame.
I suggest that the range of media interest was so significant that ministers were doing appearances on television to justify the continuation of the scheme in January 2017. Do you recall that?
I don't recall that.
The list of attachments says notification of recovery fee message, requests for advice issuing notices relating to new interest charge scheme, 10% recovery fee, request for advice issuing notices relating to new interest charge scheme. There's a couple of those. LEX or LEX, Social Security Debts Advice, issuing garnishee notices to debtors under a repayment arrangement. Media inquiry for input, the project request. Legal advice, data matching notifications and debt raising message. Do you recall receiving the email with what appeared to be a high volume of interest dealing with issues with the Robodebt scheme on that Friday?
I don't recall receiving that email on the Friday. I've certainly reviewed it since. I believe that was sent while I was on leave, and I returned the following Monday.
Monday the 16th?
Yes.
And you don't recall anything about the Robodebt scheme while you were on leave?
No, not particularly, no.
All right. When you returned on Monday, do you recall that there was a heightened awareness of issues relating to the Robodebt scheme within the department?
I don't recall that now, no.
What about within your legal team?
I don't have an independent memory of that, no.
And having read through the titles of the attachments to this email, that hasn't refreshed your memory in any way about the significant questions that were being asked?
Not about the broader context, no.
Thank you. If Exhibit 103, DSS 8001 0001 0378 could be produced. And if we go down to the email at the bottom, this is the 16th of January, the day you say you returned from leave.
Yes.
And you sent an email to Ms Metz copying in Mr Grinsell-Jones, who you said was, I think, the Deputy Chief Counsel for the Legal Services section within the department.
Yes.
And the subject was smoothing income re-debt calculation. You refer here to a conversation with Emma Kate, and you say, on the basis we can make an argument to support the position discussed. Do you know what that was about?
I know what that was about, in part informed by subsequent emails which were sent or received, and I have a memory of the gist of the conversation with Emma Kate.
All right. Firstly, who is Emma Kate?
Emma Kate McGuirk was a branch manager within the policy area responsible for debt and potentially also for means testing.
So back in December 2014, you were copied into the policy advice from Mr Mason, which Mr Jones requested, and it was the policy advice available to you prior to the provision of the legal advice by Mr Jordan, which you second counselled.
Yes.
That's the rates and means testing branch.
It would have been a section, yes.
Right.
A smaller unit.
A smaller section.
Yes.
And was Emma Kate in that area, that policy area from which Mr Mason worked in December 2014?
My memory is yes, she was the branch manager of the branch that included the means testing section.
Right. The Commission has seen some organisational charts which include a tree, as it were, with the secretary at the top, a line of deputy secretaries or assistant secretaries, and divided into various boxes. So there are divisions and then branches within divisions.
I think that we referred them as groups, but
Groups?
the concept is the same, yes.
All right. So you spoke with Emma Kate, must have been that day, your first return from holidays.
That appears so, yes.
And what do you recall of the conversation?
I don't recall exact words, but the gist of the conversation were to the effect Emma Kate wanted to discuss a particular circumstance where smoothed income was the only income available to a decision maker, and whether there was a legal argument to support decisions being made as a last resort on the basis of the smoothed income alone.
You'd addressed this topic in the 2014 advice.
The 2014 advice would have covered the same field, but the question being asked by Emma Kate, to my recollection, is quite narrow and quite different from the question being addressed in 2014.
What was the question?
The question being asked was, as I've described, in a circumstance where only smooth income information is available to a decision maker, is there any argument that would support a decision maker proceeding to act on the basis of that information as a last resort?
Well, the advice you gave in 2014 with Mr Jordan was that smoothed income or averaged income could not be taken as actual income in any given fortnight and would likely lead to errors. That's a fair summary of it?
Yes, except that the advice was, because it was given about it in response to a generalised question which was proposed to be applied across the board, it said it may not accord with the legislative framework. So it did leave open the possibility that there would be some circumstances that would not be contrary to the legislative framework.
I think we identified these when we went through the 2014 advice.
Yes.
In which you gave evidence that you understood the question was asked in the broader sense, even though the shorter phrase had been used. Was a decision of that nature legally defensible?
Yes.
And the effect of your answer was no, and a strong no, but the language you used made some allowance for the possibility that there was consistent income over the exact same period as a matter of fact, which was coincidental with the averaging over the same period.
Yes.
Something that I think you agreed with me would arise in the rarest of cases and not be applicable to a scheme on any broad scale.
Yes.
Right. So the language you use in this email is whether, well, the phrase is on the basis we can make an argument to support the position discussed. So the question that you were asked, whether as a last resort with no other information smoothing can work, had to occur in some context by reference to the concept as you've described it to support the position discussed.
Yes.
The position, as I understand this email, and correct me if I'm wrong, is the position is that the Robodebt scheme has been implemented, it is being carried out, it has come under criticism in the media and from the Ombudsman, and there is no legal advice up to this point which supports its lawfulness, and we need to find a way to make it legally work. Is that right?
I don't recall the context being discussed. I'm not saying that's not the context as you described it, but I don't recall.
Well, in paragraph 57 of your statement you say this, I'm unable to recall the actual words discussed, but I do recall that Ms McGuirk indicated that there was a departmental business need to have some means of legally justifying taking action of the nature in these circumstances. Ms McGuirk sought my assistance as part of the legal branch to provide this justification. Now, do you mean to convey by that you were asked to justify the continuation legally, that is from a legal perspective, of the Robodebt scheme, which you had said was not justified in 2014?
No, that's not my recollection. My recollection was being asked a very specific question about a specific circumstance, and I accept that the context appears to have been as you've described, but I don't now have an independent recollection of it.
Well, it can't have been anything else because the business need of the department was in the continuation of the scheme, correct?
I would have to presume it was, but I don't actually recall.
And there was a need to have some means of legally justifying taking action within the Robodebt scheme, that is action to create debts within the Robodebt scheme, correct?
Well, I was asked about means of justifying taking action using smoothed income in particular circumstances when no other income was available. To my mind, that's narrower than the entire Robodebt scheme.
And you say taking action in particular circumstances where no other information was available. We break that down into the two parts, in particular circumstances and where no other information was available. You had addressed broadly the concept of no other information being available in the 2014 advice, and What were the particular circumstances then in which you were being asked to qualify that opinion to justify the business need?
The particular circumstances were that there was no other income available, by which I presume that inquiries were unsuccessful or similar in terms of giving rise to further information, and the discussion was about a last resort capacity to take some action where the smoothed income was available and informed a decision maker.
But that's precisely the context in which you gave the 2014 advice, wasn't it? You didn't give that advice by reference to any other evidence that might be available. You only gave it in respect of smoothed income and the utility of smoothed income to a debt decision.
Yes. The 2014 advice was looking particularly at the applicability of smoothed income to the rate calculators. This request for advice I took to go to a broader interpretation of the capacity to make a decision within the social security scheme on the basis of that information.
But it would have to still be made on the basis of rate calculators, because that determined entitlement by which overpayment could be measured for the purpose of calculating a debt. Correct?
Ultimately, yes, I agree. An accurate raising of debt would need to include consideration of the rate calculators, but I believe I was being approached for a threshold question.
Which didn't take into account the legislative scheme.
Which wasn't reliant upon a direct application of the means test.
Well, was there an indirect application of the means test in the specific question?
Yes, I think that's fair to say.
How?
The application of the means test was in a context where a decision maker looking at a particular scenario, a particular individual, would look at the information provided by the smoothed income and look at the social security rate of the individual, and taking into account that context, would be able to be satisfied that the rate being paid was too high.
Because the smoothed income amount exceeded the entitlement threshold.
Yes, and exceeded it presumably to an extent that satisfied a decision maker that the various provisions in the social security law requiring action be taken if that circumstance was identified were met.
Is that the only basis on which you considered that the Robodebt scheme was legally justifiable?
I don't believe I'm saying I believe the Robodebt scheme was legally justifiable. I don't recall Robodebt scheme being expressly raised in the conversation with Ms McGuirk. I believe I was answering a quite narrow and quite technically focused general question.
Well, the difficulty with you saying that you don't believe the Robodebt scheme was raised is the evidence that you have given that you simply cannot recall the context of what was occurring socially or politically or within the office or within your department at the time that you were asked this question. You simply don't know.
Commissioner, can I object to this question or at least just ask that the witness pause for a moment when I just raise a matter with Senior Counsel assisting?
Yes, certainly.
Thank you, Commissioner.
Ms Pulford, my point was that there was an inconsistency between your earlier evidence about not having any recollection and your capacity to say that you don't believe the Robodebt scheme was raised as a positive assertion.
I agree.
You understand the inconsistency that I'm putting to you?
Yes, I agree that there is an inconsistency.
Yes.
I think it's more accurate to say that I don't recall the surrounding conversation.
But the email as you draft it suggests that there was a business need, that is, a departmental need, to justify the continuation of the raising of debts under the Robodebt scheme. That's the effect of the language you use. Would you agree?
The effect of the language that I used in the email, to my mind, is to answer the narrow technical question that was asked of me as to whether particular circumstances gave rise to the capacity to act.
Well, as a purely academic question about administrative decision-making, one doesn't need to have regard to a business need, do they?
No.
No. And if the question, as you describe it now, was as confined as you say it was, the reference to the business need and the reference to justify something is also adds nothing, does it?
I'm not sure I understand that question. Do you mind putting it again, please?
I will. And perhaps I can just be very direct about it. Did you feel pressure from within the department, particularly Ms McGuirk, who asked you this question, to come up with the basis on which you should change your 2014 advice that the scheme generally was not legally defensible?
I believe I felt pressure from Ms McGuirk to provide an answer that justified taking action in circumstances which the broad general advice in 2014 would not have supported on its face. I now cannot recall whether that was done in full awareness of the Robodebt scheme being in full flight or not.
If that email could be brought up again. And that part could be uncalled out. And if we just go to the top part of it, now, the reference there, actually I've taken those out of sequence. The second email on the page could be called out, please. My apologies. Your response to Ms Metz copying in the Deputy Chief Counsel was that you've opened a new Lex, as this issue doesn't seem to have been directly canvassed in your previous advice. Let me know if you have, if a different approach is preferable. When you say your previous advice there, whose advice are you referring to?
Based on the document, it appears to be advice relating to Ms Metz.
It does. Are you aware of any such advice in the material you've read in preparation for this hearing?
I have reread the emails attached to the email Ms Metz sent to me on the Friday before returning to work again, but that doesn't cause me to be able to offer any light on what that was referring to.
All right. If we go then to the email at the top of the page. Ms Metz replied, "That's fine with me, Anne. I didn't advise on this at all. I just forwarded Simon's advice to Alan. Took me a while to locate, so I just put that search time under a related Lex." There may have been some confusion about whether she advised or not.
There may have been.
And the reference to Simon's advice is the reference to the Jordan advice, which you second counselled in December 2014.
I believe so.
Which was directly relevant to the broader question.
Yes.
Right. I asked that Exhibit 81 DSS.8001.0001.1293 be brought up. This is an email from Ms McGuirk to you on 18, that is the following day, 18 January 2017, where she says, as discussed, I'm looking for advice, please, regarding a last resort method of debt identification for income support recipients. She identifies that the Act requires a fortnightly income test, which is applied for standard debt raising. However, in circumstances where there is available information about employment income and it appears to be an overpayment has been made, but no available information from the recipient or ex-recipient about the period over which the income was earned, is it lawful to use an averaging method as a last resort to determine the debt? We'll pause there. This is the question as it has been identified for the first time in writing as opposed to in a discussion. And it's clear you would agree with me that the question in that phrase is really a rehash of the 2014 question about whether smoothing income is legally defensible.
Yes, I don't agree with that. I think that this is not intended to be a general question about whether using smoothed income is legally defensible, but is directed to a particular circumstance which would come within the broad scope of circumstances covered in the 2014 advice where particular criteria as set out in the email are met.
Well, the available information to which this question, as it's phrased, relates must be smoothed income from the ATO, correct?
Yes.
And the issue you identified with that was that it is not likely to produce an accurate indicator of actual income. That's in 2014.
In all instances, yes, correct.
And this doesn't identify the circumstance in which the period during which the recipient received social security benefits aligns directly or almost directly with the income, does it?
No, it doesn't.
And so it was a broader question than at least you understood from your conversation, as you recall it.
I don't think this is a broader question than the question I broadly described in what I recall of the discussion with Ms McGuirk.
What's the difference then, to your mind, between using the averaging method of smoothed income as a last resort to just using it in the manner in which it was proposed in 2014? Don't you arrive at the same factual point?
There is a difference in terms of having no other income available, which, to my mind, as I said, not recalling full context, implies a more active investigation by an officer of an individual's circumstances before looking solely to the smoothed income.
But despite all the investigation in the world, if all you're left with is smoothed income, you still arrive at the same answer that you gave in 2014. Legally, the absence of evidence doesn't amount to positive proof of a debt, correct?
Perhaps the advice that I ultimately provided takes a different perspective on the question as to whether that accurately determines the debt.
I ask that Exhibit 92, DSS 5032.0001.0009 be produced.
Just while that's happening, can I ask you, Ms Pulford, you said that there was an implication that there'd been some investigation, that no other information implied that to you? Or perhaps the use of the word last resort?
Yes, Commissioner.
Did anybody suggest any of these, that there was any investigation in the Robodebt scheme of people's debts by DHS staff?
With hindsight...
People's income, I should say, really, rather than their...
Yes, yes. With hindsight, I agree that there wasn't, and I'm unable to be accurate now as to the degree to which I understood the full extent of the Robodebt scheme at that time.
All right, thank you.
If we could just go to the last page of the email trail, which makes up Exhibit 982. Thank you. Now, we're moving forward a little bit here, but if we go to the last email in that sequence and ask that it be called out, that is the email from Louise McLeod. As the trail demonstrates, you came to be copied into an email which had this as the start of it, and it was an email from Ms McLeod, the Acting Senior Assistant Ombudsman, Sunday 19 February 2017, and I'll pause there to note that you ultimately answered the request for advice made by Ms McGuirk on the 24th of January 2017, that's correct?
Correct.
So we are 3 or 4 weeks on from that. And Ms McLeod's request is addressed to 2 people. We don't need to deal with that at the moment. But it says in the first paragraph, during the course of our investigation, we've identified an issue we need to raise with DSS. It concerns the authority for averaging employee income across a full or part financial year where the dates of employment cannot be verified in order to recalculate a person's social security entitlement and therefore an overpayment requiring recovery. DHS has told us that it always used averaging as a last resort. We'd like to understand more about the authority to do this. We've asked DHS to provide copies of legal advice about averaging and overpayments, and the request is the same from DSS. So by the time you're copied in, you understand the context of the fact that there is a live Ombudsman's inquiry directed towards the very advice you gave in 2014. All right. If we could go then to the next email. Sorry, these are the sequence, just forwarding it. Go back to the previous page, please. Ending 0011. Thank you. And if we could pull out the centre part of the page starting from Ms Pulford, 21 February 2017, down to Rob Herman. Thank you. Now, Mr Herman forwarded you the request from the Ombudsman on Tuesday, 21 February, and said, we are proposing to provide the attached legal advice you sent through in late January in response. We just wanted to check that it was okay and there was nothing more or recent or better suited or anything else you thought should be done. If we go then to the top, the same day you respond quite quickly to say that you had identified the earlier advice provided by the team in late 2014 in relation to the same issue. That's right?
Yes.
You attach it
Yes.
and identified that the request would seem to be within the scope of the Ombudsman's request. That's right?
Yes.
To be frank, it was very squarely within the scope of the request, wasn't it? And there was a discussion about how that would be managed in respect of the Ombudsman's response.
Mm-hmm.
We go then to the previous page. And go down to Mr. Herman's email at the bottom of the page later that same afternoon. Now, Mr. Herman, I'm not sure I asked you where he fitted in the scheme of things.
He was at that time the director of the debt and compliance team.
Within DSS.
Yes, within DSS.
And there was a discussion between, or an email from him to Russell de Berg about whether the 2014 advice fell within the Ombudsman's scope of inquiry. That's right?
Yes.
As you read that, either back in 2017 or more recently, would you agree that there appears to be an attempt to read very finely the language of the Ombudsman's request so as to carve out the 2014 advice?
That appears apparent from the document, yes.
All right. And if we then go to the next email. This is Mr. Herman to you, Wednesday 22 February. As discussed, there must have been a conversation you had in which he conveyed to you that the 2014 advice was not going to be provided in response to the Ombudsman. That's right?
Yes, I presume so from the documents.
And did that appear to be to you to be consistent with the department, that is DSS, position that the advice you provided on the 24th of January 2017, and we'll come back to its contents shortly, but it effectively gave a green light to some aspects of the Robodebt scheme, you would agree? Perhaps that's a longer conversation, we'll come back to it, but that there was, in the sequence of events, a desire to give your 2017 advice rather than your 2017 advice with your 2014 advice.
Yes, that seems to be the document's indication.
And having read both advices recently, you appreciate that there appears to be an inconsistency.
There may appear to be an inconsistency, yes.
All right. Going then through the sequence of emails which followed at the top of the page, it appears that you made some effort to ensure that the 2014 advice was provided to the Ombudsman. That's right?
Yes.
And you do that by reference to the fact that you discussed it with your branch manager. Who was that?
Alan Grintle-Jones at the time.
Right. And then what follows after it is accepted that the legal position adopted by your team is that both the 2014 and 2017 advices should go to the Ombudsman is a discussion about how that could be explained, that apparent inconsistency.
Yes.
Right. So if we go then to the two emails at the top, or the first half of the first page. Thank you. The one at the bottom is Mr. Herman accepting the position that both will be given to the Ombudsman, but he says, given the two advices may appear to come to different conclusions, would it be possible for you to provide a joining paragraph that could be forwarded on that outlines why they appear different but don't contradict each other? We would then include it with the information we provide the Ombudsman along with the two pieces of advice and the information about legal professional privilege. That's right?
Yes.
And your explanation was this, at the top of the page, and perhaps we can just focus on the top email. Thank you. You say the 2014 advice relates to the process of rate calculation under social security law and indicates the method of generating an accurate debt amount on the basis of full information. I pause there. The full information, of course, that was considered for the 2014 advice, as you've said recently, was averaged income over a period.
I believe what's being referred to here as full information is in order to generate an accurate debt, it would be necessary to know the periods over which the income was earned.
Right. By contrast, the 2017 advice identifies circumstances in which the Secretary would be obliged by the Social Security law to take action to adjust a rate of social security payment despite not having full information to generate an accurate debt amount. The advices are consistent but address different levels of available information to ground administrative decision-making by the Secretary. The adjustment to a rate of social security payment suggests that someone is currently receiving social security.
Yes.
Is that what you intended to convey?
I believe that would be applicable to past rates also.
That is, we're back into the area where, despite not having full information, although full information, as you've described it, is the amount of income earned in any particular fortnight.
Correct.
And from that it follows you can't identify the actual earnings. And from that it follows you could not be confident that there was an overpayment. Correct?
You would not know with absolute certainty that there had been an overpayment, correct?
Well, you would be guessing, wouldn't you?
You would have to be making a decision on less than complete information.
Well, at one end there might be a lack of absolute certainty where information is not complete. At the other end, incomplete information might lead to guesswork. But fundamentally the point's the same, isn't it?
No, in this space it is reasonable for a decision maker to act on the basis of information which on the balance of probabilities is justified.
All right. We go to Exhibit 90, DSS 5006 0001.2713_R. This was the advice you provided to Ms McGuirk on 24 January 2017.
Yes.
And if we just pull out the top two paragraphs of that, thank you very much. You rephrased the question, as is the ordinary process, and we've seen that in other advices. You've asked about whether using income averaging as a last resort to determine a social security debt was lawful. Taking out the words last resort in that sentence, it's the same question as 2014, isn't it?
Yes.
In circumstances where no other information about the person's circumstances are available, we are providing this advice on a general basis without details as to what information source is being used and for what period. We would appreciate you treating this advice on this general basis. With this proviso in mind, the answer is yes. The qualifications you introduced into the question at the top make it impossible to identify a practical application of that, don't they?
Yes.
This was the most hypothetical advice that could be provided to legally justify some aspect of the scheme then in existence, correct?
It was hypothetical advice in response to the question I was asked, yes.
With so many qualifications, it appeared to you to have no real practical application.
I wouldn't agree it had no practical application. I think the advice at the end invites provision of scenarios so that a practical application could be teased out.
Well, we might work our way through it. But in the second paragraph, you say the Secretary must be guided in their decision-making by a range of information they are able to obtain and whether this casts sufficient doubt about the correctness of the rate of social security payment to justify taking action. That phrase, casts sufficient doubt, is different to the question of proving a debt, isn't it?
Yes.
So casting doubt about something by incomplete information doesn't permit a decision maker to affirmatively establish a debt, does it?
Correct.
You must have understood that you were being asked to walk back the clear terms of the 2014 advice in the context of what was happening in the public arena with the social security, with the Robodebt scheme.
As I've said, I don't recall the context accurately at this stage, and I believe I was answering the question I was asked to by Ms McGuirk.
We go to Exhibit 91, DSS 5.5006.0001.2398. And if we go to the second page of the advice, sorry, the document. Sorry, the third page. No, the second one. Sorry, the second page. Thank you. This is an email trail which is between Alison McCann, Mark Withmull and Parmesh Singh, which starts at the bottom of the second page. Could I please have a copy of the latest version of the letters Annette wants to share with DSS Legal, EOM. What's EOM mean?
End of message.
And the Annette that is referred to there is Annette Musolino?
I presume so.
The letters are then forwarded through the chain up to Annette Musolino, who sends them to Mr Stepniks and asks him to provide them to you to see if we can get a joint sign-off. What was the reference to the joint sign-off? At least as you understood it.
Well, that would be a request to see if we can agree upon a correct form of letters or advice. I'm sorry, I'm not entirely sure what this is relating to.
I suggest it was related to the inquiries made by the Ombudsman about the position of legal advice to justify the continuation of the Robodebt scheme. You can't recall?
No, I don't recall that.
And by Thursday, the 26th of January, at the bottom of the first page, the letters come back to you. Do you recall requesting the letters?
No, I don't recall.
It would make sense that you requested the letters given earlier advice about the 10% recovery fee and the need to ensure that the letters were a notice under Section 68 of the Administration Act.
Yes, that's correct.
Because I think, as you indicated to the Commissioner, they plainly weren't in the versions you had earlier seen.
Yes, correct.
And there is a reference to the debt recovery provision in Mr Stepnick's email. And it appears as though that advice came from DHS.
Correct, that's advice about the late payment penalty element.
It's summarised to say, in short, the provision being the the debt recovery penalty operates to impose the penalty unless the Secretary is satisfied there's a reasonable excuse. Again, skipping over the fundamental threshold of whether there was an obligation to provide information. Yes. And then if we go to the top of the page, it appears as though the end of this email trail deals with you saying that the advice is not problematic. This is the advice about the recovery penalty, referred to below. But the legal views expressed are not clear in relation to persons who do not contact the department, and that approach would not be clearly supported legislatively. Do you see that?
Yes.
That is, there remained a difference of view, at least between yourself and DHS, about the applicability of the recovery fee in the online environment.
It appears so, yes.
Do you recall any other advice provided in the course of 2017?
About the Robodebt scheme?
Yes, of course.
I don't think my review of documents has revealed other significant advice.
All right. Before going to 2018, I'll just deal with one final email in respect of the Ombudsman's report. If Exhibit 112 DSS.8001.0001.3405 could be pulled up. And we go to the bottom of page ending 3406. Again, an email from Ms McLeod, two persons, Verity and Stephen, referring to the Ombudsman's notice and the own motion investigation. It says, on 20 January 17, DHS provided our office with an attachment, which is an executive minute briefing the Minister for Social Services and the Minister for Human Services, dated 12 February 2015. Now, that was the signed attachment to one of the earlier emails that we identified today, which you have read recently, and what was contained in that was there may be a need to be a change of policy to enable the use of ATO data in this way. DSS has also advised that legislative change would need to be implement this initiative. As a result, we have been working with DSS developing this proposal and will continue to do so. And advice from DSS was sought. That is the advice that had been given, correct? Prior to the minute.
I beg your pardon, that last phrase?
The Ombudsman, or Ms McLeod, requested the advice that had been given in respect of that aspect.
Yes.
There goes through a series of exchanges, and that leads, if we go back to page 1, with just below halfway, Mr Grinzel-Jones forwarding you the email trail to which we've just seen on Tuesday the 28th of February 2017.
Mm-hmm.
All right. There's a reference to Kath again. Does that help you identify who Kath was?
Yes, I think it was in one of the other emails you've shown me recently, Kath Halbert.
Thank you. And because you were the author of the 2014 advice in your second council role, it makes sense that you would receive this email trail for your consideration. Can we go to the top and your response? Can you just take a moment to read that?
Yes, I've read that.
All right. For context, it was in the previous week, Wednesday the 22nd of February, that you had exchanged with Mr Herman the email we went through earlier, where he asked you for a bridging paragraph for the two advices which appeared to give rise to some inconsistency. And you are now again talking to Mr Herman, identifying that although there had been agreement from your legal team to provide both advices, you are making it clear, as I understand it, that the decision to provide both occurred at Deputy Secretary level. Is that right?
The decision about whether to provide both was...
Whether to provide both. To be clear, to your knowledge, had the 2014 advice been provided to the Ombudsman at this point?
I don't have an independent recollection, and the email tends to indicate it hasn't.
Yes. What is written here is really a rehearsal of positions which identify that if there had been a decision not to provide the 2014 advice, that came at Deputy Secretary level, correct?
Yes, that's what it says.
Is that Serena Wilson?
I think it would have been, but I'm not absolutely sure on that. 2017.
You say that since then DSS policy has become more comfortable with DHS's approach of using smoothed income, given it is being applied as a mechanism of last resort where no more accurate information is available. This appears to represent a change in DSS's position, although it doesn't represent a change in the legal position. Surely it did represent a change in the legal position. Smoothed income could not be used to identify debts.
Well, this is indicating the DSS policy position, the overarching DSS position,
Right.
into which legal advice is an input.
An input. I think you described it earlier as legal advice being a consideration of risk amongst other considerations of risk that a
Correct.
department takes into account.
Correct.
Surely, though, there must be place for the fact that the law remains the law no matter what policy is.
And that's what I think I wrote here. There's no change to the legal position.
Right. That is, the system remains legally flawed.
I think that's what that email is saying, yes.
Right. Do you know whether the 2014 advice was provided to the Ombudsman?
No, I don't know.
Did you follow up at all?
I don't recall whether or not I followed up.
Did you become aware after the Ombudsman published its report that the department was relying on the Ombudsman's report as a validation of the legality of the Robodebt scheme?
Do you mind repeating that question?
You recall that the Ombudsman published a report in April 2017?
In very vague terms, yes.
Do you recall that after the report was published, that is in the years after the report was published, the department publicly asserted that the Ombudsman's report provided some legal validation for the scheme or did not find any legal flaw with the scheme? That it satisfied legislative requirements, words to that effect?
I'm sorry, I don't have a memory of that.
I'll move now to 2018. Your department, or your team rather, was involved from time to time on appeals or the consideration of whether to appeal a first-tier administrative appeals tribunal decision.
Yes.
And you were familiar, I take it, with standing operational statements between the Department of Social Services and the Department of Human Services, which required the Department of Human Services, who had carriage of those appeals at first instance, to advise DSS in certain instances about a decision in the AAT Tier 1, which might affect policy or have significant publicity attached to it or the like.
Yes.
And in 2018, one such appeal came across your desk or the desk of your team.
I have no memory of that.
Do you recall Ms. Anna Fredericks?
Yes.
She was in your team in 2018?
Yes.
And do you recall that advice was sought from Clayton Oots about a particular AAT decision that had been referred to DSS by DHS?
I have reviewed documents which indicate that, yes.
Relating to a Mr. Earl?
Yes.
Are you saying to me that you have no recollection now, independently of those documents, of these events in 2018?
Correct, that's what I'm saying.
If Exhibit 76, DSS 8001.0001.5209 could be displayed. And I think the advice is, if we could just sorry, I think that's the wrong document. Sorry, Exhibit 135, 5006.0001.42.42. Recall from your review of documents that this draft advice from Clayton Utes was addressed to Ms. Anna Fredericks, a principal lawyer in the branch and the team in which you operated.
Yes.
And it arose from a request dated 23 July 2018 about the use of income averaging as a method for determining a person's income for the purpose of the income and assets test, which can be used to determine a social security debt.
Yes.
Again, broadly speaking, in fact, almost identical to the question that you addressed in 2014.
Yes.
You were aware, I take it, from the documents at least that you have reviewed, that this was a topic of discussion amongst the team, that the advice would be sought.
From the documents I reviewed, yes.
And it was, you would have appreciated at the time, a significant step to go outside of the Department of DSS to obtain external legal advice.
It was something that we did for a range of matters.
To your knowledge, it was the first time that it had been done in respect of the Robodebt scheme.
Within DSS, yes.
And you had no other knowledge of any external advice within DHS?
No, I had no other knowledge.
Had you considered the question of external advice in 2014?
Well, I now can't say accurately whether I did consider or not, but it's not likely that I would have, because there was no particular contention about that advice at the time, no particular increased level of risk for the department that I would now identify.
What about in 2017? January 2017, following Ms McGuirk's request? And the business need. Did you consider it then?
I don't have a memory as to whether I considered it then.
The events that you've been able to read about in January 2017 suggested that there was a very high level of risk and media associated with the scheme in January 2017.
Yes, again, I don't recall. I don't now have an awareness of the level of media interest in January 2017.
Right. We just deal with the summary of the advice and go to the first paragraph under the heading Summary Advice on page 1. In our view, the Social Security Act in its present form does not allow the Department of Social Services to determine a youth allowance or New Start's recipient fortnightly income by taking an amount reported to the ATO for a person as a consequence of data matching processes and notionally attributing that amount to or averaging that amount over particular fortnightly periods. You see that?
Yes, I see that.
If we go then to subparagraph B. Information obtained from the ATO as a consequence of data matching would seem useful for flagging circumstances where a person may have been paid a greater amount of income in fortnightly periods than they had declared to the department in respect of each period. The department could ask for further clarification from the welfare recipient in those circumstances, bank statements and payslips, and could also obtain copies of payroll records from the relevant employers by exercising information gathering powers available to it. You see that?
Yes.
The advice continues and includes, as you would note from your recent reading of it, the decision of the tribunal relating to Mr Earl, that is the Administrative Appeals Tribunal, who had in turn referred to an academic article written by Mr Terry Carney entitled "The New Digital Future for Welfare, Debts Without Legal Proofs or Moral Authority." You're familiar with that reference in the document?
I'm familiar with that reference, yes.
The draft advice was provided to you. We go to Exhibit 129, DSS.5004.0001.5275. We start on the second page, ending 7.6. can see that Mr Staples from Clayton Oots sent the draft advice on Tuesday 14 August 2018 to Anna Fredericks in your team, and it was copied to the authors of the advice, who were a partner and special counsel respectively, Mr Sibley and Mr Bird.
Yes.
The question asked was, we are happy to discuss the draft advice prior to finalising. You see that?
Yes.
We go then to the email at the bottom of page 1, ending 5275. Ms Fredericks forwards it to Ms Metz and yourself. Attached is the draft of the Clayton Oots' advice on the legality of income averaging. Kane and John Bird called me to discuss, as the advice is somewhat unhelpful if the mechanism is something the department wants to continue to rely on. Kane advised that they might be able to rework the advice subtly if this causes catastrophic issues for us, but that there is not a lot of room for them to do so. You see that?
Yes.
Surely by now you appreciated, given whatever the view that you expressed in 2017 through the Ombudsman's process was, that the department had in its possession an external legal advice which said that the Robodebt scheme was not lawfully sustainable. You appreciated that?
Yes, I presume I did. I don't recall the details of this advice, but I presume I did.
The use of the word catastrophic in this email was a recognition of the significance of the advice to the Robodebt scheme, wasn't it?
Yes, I presume that's what Anna intended.
Yes. That's how you certainly understood it.
I don't have a memory of the issues at the time.
You must have dawned on you at this time that this was one of the more significant legal advices in respect of an issue that you had been dealing with since November 2014, a period of almost 4 years. Correct?
Well, I'm not saying it didn't, but I don't now recall.
We go to the email at the top of the page. You forward it to certain persons, Ms Lumley, who you've identified previously. Who is Philip Mufarage?
Philip Mufarage was then the director of the Debt and Compliance Policy Team.
And Paul Dowling?
Was an EL1, Executive Level 1 policy officer within that team.
Your email says that attached, please find draft advice from Clayton Oots on our questions regarding income averaging. They conclude the approach is not supported, although not for the reasons suggested by Mr Carney. Let me know how you'd like to progress this, given the conclusion and limited room to adjust the outcome. You are signalling there that this advice, if accepted, means the end of the Robodebt scheme.
That's a very... I don't recall what I was trying to signal by those words. I'm certainly signalling that the advice is not legal, the approach is not legally supported by Clayton Oots' draft advice.
Well, Ms Fredericks had used the word catastrophic in her email. Plainly, that was a reference to the end of the Robodebt scheme.
I can't comment.
Well, she's in your team. Did you talk to her about it?
I don't recall. I'm sorry.
Well, this obviously wasn't the end of the conversation. Your email forwarding it to Kristen. What happened after that?
I don't know. I don't believe I have further records in writing of things that may have happened after that.
You've not located any emails?
No.
Where have you looked?
My solicitors have helped in terms of running search terms through the areas to which I was directed by the notice to provide a statement, and we have not identified further relevant emails.
Did this just disappear into the ether, this external advice?
I can't say.
Do you recall anything in 2019 occurring in respect of the Robodebt scheme? Anything at all? Publicly, within your department, anything at all?
I think 2019 was when the class action occurred. So yes, I recall that happened. I wasn't directly involved in the advisings at that stage.
Do you remember that there was an announcement that the scheme would be suspended in November 2019?
I don't recall an announcement, but with hindsight, yes.
Do you recall in 2019 that the Federal Court made orders by consent with the Commonwealth that in the case of Amato and the Commonwealth? You remember that?
As I said, I wasn't directly in this particular legal space at that time, so it's difficult to positively say I remembered it at the time. I'm certainly aware of it now.
Do you remember in 2020 that the scheme was ended in May 2020 by the government?
I recall the scheme was ended in 2020, yes.
And at that point it must have been clear to you that the advice you gave almost 6 years earlier that there was a legal flaw in the assumption in order to raise a debt was correct? Did you not remember throughout each of these years, 2015, 16, 17, 18, 19 and 20, that there was a significant issue in respect of the lawfulness of the Robodebt scheme which led ultimately to the position about which you advised in 2014?
I can't now say that I had those things top of mind in each of those years. As I indicated, I am not an ultimate decision maker about decisions such as this scheme.
Surely there was a discussion in 2018 after you forwarded the email to Kristen Lumley where you said, what are we going to do with this advice? They've said that there's not much room to move on it, and someone's appreciated that it might be catastrophic for the scheme. Do we get it converted into a final, or do we pay their bill and walk away? There must have been that discussion.
I presume that there was, but I have no recollection as to whether that was a discussion that took place and whether it was with me or not.
Just one moment, Commissioner. Do you have any knowledge now of whether the invoice for the advice was paid?
I do have knowledge now.
And how have you gained that knowledge?
I've gained it because my current practice management unit followed up on the payment of the advice historically for 2018 and obtained information about it that it had been paid.
Who is your current unit?
I'm currently within the Social Security and Families legal team within Legal Services. We are a group.
And did they identify, when they looked at whether the invoice had been paid, whether it was converted from draft to final?
The information that I have seen does not indicate that it was converted to final. There is no indication of any conversations beyond the provision of the draft advice.
So, on the inquiries you have made about what happened to this advice after that email, all you can identify within the department and all that your current team has been able to identify is that the bill was paid?
As far as I'm aware, yes.
Does that strike you as extraordinary?
No.
This advice plainly had great significance to the Robodebt scheme, didn't it?
Yes.
And you can find no record where it was converted to a final draft with signatures.
Correct. I can't find a record.
Where's the line between losing something and active concealment in your mind?
I object to that question, Commissioner.
On what basis?
Firstly, it's unfair to put that kind of allegation to someone in the manner in which it's put, given this is a person who is not the head of the department and has a very defined role to play.
It's not exactly an allegation. It is a question as to where a line falls. But I think actually it's a little vague. Where's the line between losing something and active concealment? I don't know that there's a suggestion anything was lost, so I'll disallow it on that basis, I think, Mr.
No,
Rayner.
please.
Why isn't it extraordinary that this advice was not finalised in draft form?
Because departmental practice is when external advices are obtained, they're obtained in draft and then they are reviewed and a decision made by the relevant client area as to whether they wish to finalise the advice.
And if the advice is not finalised, is it treated as not having been given?
It's certainly treated as not representing the departmental's preferred view and arguably still open to further discussion or comment or potentially a revision.
So what do? You get an advice in draft, and if it's not favourable, you just leave it that way. And then it never represents anything that you deal with. Is that the approach?
Yes, Commissioner.
And is that done regularly in the department?
It's certainly happened many times that I have seen it, yes.
I'm appalled. Anyway, I'll leave it with you, Mr. Gregory.
Who's the relevant decision maker for that decision?
The line area, the policy area for whom we have obtained the advice.
And in 2018, who was that?
That would have been the stream, including Philip Muffarridge's team for debt and compliance.
Is it his decision whether to finalise that advice or not?
The decision making within the policy areas is a matter for their internal organisation, and I couldn't necessarily comment on saying whether that would have been, if such a decision were made, it would be necessarily made at director level or at a different level.
Well, would Ms Lumley have anything to say about it? You directed the advice to her and asked for her input.
I would have anticipated that Ms Lumley would be conferring with her line of seniority to make those decisions and to provide feedback.
So the closest we get from your evidence about what happened to this advice is the three persons who are identified at the last stage of it, as to where it went.
Yes, yes.
Thank you, Commissioner. Nothing further.
Ms Hogan-Doran?
Commissioner, I don't have any questions for this witness.
Thank you. Mr O'Neill?
Commissioner, an issue has arisen during the course of my learned friend's examination, and I need to seek instructions about it. I
You
know
need
that's
to talk to your client?
I do, and I know that's inconvenient for you, Commissioner.
How long do you need?
I only need 5 minutes.
Sure. We'll adjourn. I won't go anywhere. I'll be on hand. So if you would let my associate know when you're ready, Mr.
I'm most
O'Neill.
grateful. Thank you, Commissioner.
Thank you.
All rise. Commissioner stands adjourned for a 5-minute break. The Royal Commission is resumed.
Mr. Redding.
Commissioner, thank you for that moment.
Subject of the live stream being paused and non-publication? I just thought it was the personal nature of a medical.
I was going to ask this question, and then I was going to say that it needn't be, but I understand what Commissioner says, and I agree. Yes.
All right. Well, the live stream can be turned back on then, and it is only the nature of the medical condition and the treatment in respect of which the non-publication order until further order applies.
Thank you, Commissioner.
All right. You said you were left out of discussions. I think we're up to it.
So you were left out of discussions, and I said, what was the impact in respect of that matter on your ability to follow current affairs at the time, if any? Would you like me to rephrase it? Were you following current affairs during that period of time when you were receiving treatment?
Probably not as closely as I would have been were I not receiving treatment.
Thank you. Now, a different topic. I'd be grateful if exhibit, I think it's 71, DSS 8002 001 0228 could be displayed. Ms. Pulford, what is this document?
As its title says, it's the DSS Legal Practice Manual, and it sets out the policies and procedures that we within the DSS legal practice were expected to follow.
Whilst this one is 2016, was there an earlier version of it, 2014?
I haven't been able to locate it, but I'm confident that we've had policies of this nature throughout the time I've been in the practice.
At page, if 0234 could be brought up, please. Can you see number 3, understanding the client's business?
Yes.
Pausing there, who is DSS Legal's clients?
Our clients are the main policy provision areas within the department who actually escalate policy advice to decision makers within the department and ultimately to ministers.
And how many of those are there in terms of how many clients are there?
Oh, many. Hundreds.
Below that, under the subheading receiving instructions, it says that you receive instructions by email, phone or in hard copy. Is this consistent with the way in which you conducted business throughout the period of 2014 to 2018?
Yes, I think it is.
If page 0248 could be brought up. Now, this section appears to deal with Lex, is that right?
Yes.
And Lex is, I think you told Senior Counsel Assisting that it's the matter management program used internally, is that right?
Yes.
And the Commissioner has received some evidence about Lex numbers. Are Lex numbers raised in order to indicate that a new matter has been opened or with the client?
Yes.
And that's done each time a new request for advice is received, is that right?
Yes.
And it is even to the extent that time is recorded by individual lawyers as against that matter. Is that right?
Yes, at the time, yes, that's right.
Then at 0252, now this is a guide on how people in your area provide legal advice, is that right?
Yes.
Now, if the second paragraph under what is legal advice could be highlighted and drawn out. Starting, legal advice should be distinguished from policy or commercial advice. What is your understanding of the distinction being drawn by the manual between legal advice and policy advice?
Yes, well, legal advice is about identification of legal issues or risks raised by a particular proposal or question, whereas policy matters are far broader and go to an approach in terms of social policy for my department, which may be suggested to decision makers.
And the answers that you gave Learned Senior Counsel assisting in respect of the distinction between risk, is that to your understanding what the manual is driving at in this section?
Yes, that is my understanding. It is not DSS Legal's role to make a policy decision as to whether a matter proceeds. That is the policy decision. We provide the legal advice and highlight the legal risk for the policy area.
What about the implementation of advice? Where does that fall? Does that fall outside of what the manual is directing you to give advice in respect of?
No. The area you highlighted earlier talks about the fact that we are to be the trusted advisor of our client areas, which means that we are expected to influence client areas to take heed of advice and to follow it to the extent that that is feasible, but it accepts that our overarching job is to further the business of the department and to find constructive ways of allowing things to happen rather than not.
And then at 0255, the manual deals with the procurement of external legal services. Do you agree?
Yes.
And that requires, the procurement of external legal services requires approval of the Deputy Chief Legal Counsel or the Chief Legal Counsel, is that right?
It did at the time, yes.
Has that changed since?
Yes, it has. There are a variety of differences of approvals.
I see. But relevantly, in terms of your role at the time of the obtaining of the Clayton Utes advice or even prior to that, it would have been a decision at a higher level than where you sat for procurement of external legal services to be, external legal services to be procured, correct?
Correct.
Where external legal advice is procured under that approval, what is the person who obtains that advice's role in ensuring that it goes to the relevant client?
The role is to ensure that the advice goes to the people who sought it, that they understand the advice, that they are offered any guidance which are apparent to the procuring lawyer as to how they might consider progressing the advice, and then to respond to requests, including requests to finalise or potentially not finalise the advice.
And then internally, is the matter within Lex, is it closed off so that no more time can be recorded against that matter?
Generally, yes.
Does this manual say anything about deciding whether or not to get a final advice or leave something in draft? Well, perhaps we can look for ourselves.
The relevant section of the manual continues across to the next page, Commissioner. Again, I'm not going to answer the question at danger of putting myself in
All right.
evidence, but
Let's see.
that's the full section.
I wasn't waiting for an answer.
Oh.
I had said we can look, and no doubt, Mr. O'Neill, if there was something critical, you'd be taking your client to it.
Certainly, Your Honour, and I'm good, Commissioner, and I'm going to move on. You asked a series of questions by a learned senior counsel assisting the Commission about the distinction, if any, between your 2017 advice and the 2014 advice. Is it correct that the 2014 advice concerned the raising of a debt?
Yes.
And can you explain what the raising of a debt means to the Commissioner in the context of that 2014 advice?
Well, in the context of the 2014 advice was sought on whether income information which did not relate directly to fortnights could be used to accurately raise a debt where it was shown that more income was available to the person than perhaps had been declared when their rate of social security was originally calculated. And it concluded that it may not be in line with the statutory provisions to apply income that did not relate directly to fortnights in that way.
The 2017 advice appears to relate to the taking of action by the Secretary. Is that right?
Correct.
What's the taking of action involve?
The taking of action in the 2017 advice was by reference to sections 79 and 80 of the Social Security Administration Act, which if the Secretary or decision maker is satisfied that the rate of social security being paid is greater than the rates which should be paid under the social security law, it requires the Secretary to reduce the rate to the rate provided for by the social security law.
So is there a distinction then, to your mind, between the taking of action and the raising of a debt?
I think that there is, because the reaching of satisfaction and hence the triggering of section 79 or 80 may be, as the 2017 advice asserts, may be met by smoothed income in a particular circumstance where there is sufficient information to satisfy the decision maker that the rate that was being paid is greater than that provided for by the social security law. Having done that, 79 or 80 dictate actions, including reducing rate or suspending or cancelling a payment. And the smoothed income doesn't go directly to accurately determining exactly what action would be taken in a particular circumstance based upon smoothed income.
So the taking that answer, the taking of action could be indicated by there being a mismatch between the smoothed income and the lack of information that had been provided, correct?
Correct.
And then once that had been raised, it was open to the Secretary to then take other courses of action in order to then determine whether a debt could be raised, correct?
Correct. And
the raising of a debt in that instance the smoothing couldn't be used to accurately determine the quantum of that debt.
Correct.
The 2017 advice also deals with a concept known as or deals with what information is present before the decision maker at that time. And I think it uses absence of full information. What is full information?
full information would be both the timing and the amount of income receipt by the Social Security recipient.
And so, again, in the absence of full information, the Secretary, in accordance with the 2017 advice, could take some action to initiate an investigation, for example. Yes?
Yes.
And then, but couldn't use the smoothing information to calculate the quantum of the debt that may be raised as a result of that action.
Correct.
And does that adequately explain to the Commissioner the consistency between the 2017 advice and the 2014 advice, to your mind?
Well, I might have to judge the adequacy of it, Mr O'Neill.
Certainly, Commissioner. It was really an open question to see whether there was anything else that might assist you to understand the consistency between the two of them.
Is there anything else do you want to say about it, Ms Pulford?
I would like to say that, to my mind, there would be relatively few circumstances which are likely to, as a result of the 2017 advice, result in action being taken by a decision maker. And it is, to my mind, a very narrow effect of advice, whereas the 2014 advice was obviously across the board.
Thank you. I've no further questions, Commissioner.
Thank you. Mr Gregory, anything further? All right. Yes, thanks, Ms Pulford. You're excused. Thank you. We're getting close to 4:30.
Yes, the next witness might take us a little beyond that, is in closer to 5.
How much longer than?
Yes, closer to 5, I would think.
Would she be done by 5? I assume she's come up from Canberra, has she?
I'm not in a position.
Sorry, Ms McGuirk is present. Mr Brown has been waiting online. If he's not to be reached, perhaps he might be released.
Yes, absolutely.
And I'll have to speak with Senior Counsel Assisting in relation to when he comes back. If not tomorrow, Friday, he's ready to...
Yes.
I'll just have
What about Ms McGuirk? I'm just trying to work out, is there...
Ms McGuirk is here and is keen to press on, yes.
Now, how does that suit everybody else, and do we think we can complete it by 5? I don't want to stay much after that, I don't think. Puts everybody out.
My impression of her evidence is it could be completed in half an hour, but of course, I mean...
Mine too.
All right. Mr O'Neill, how are you placed?
It's certainly convenient that her evidence be heard now for our camp. It's the only other witness where...
So it'd be better for you?
Yes.
All right. And Deloitte's, I imagine, cope? Yes, they seem to think so. All right, we'll push on.
I'm not sure where Ms.
Well, Commissioner, while that's while the witness is being located, earlier today I gave a commitment to resolve privilege and public interest immunity markers on the 16 documents related to Ms Keeling's evidence. That's been resolved as between us and those assisting you, and I think that's the only thing I need to update you on.
Ms Hogan-Doran, can I say I very much appreciate the effort that you're putting in to make this as smooth as possible. It's evident and it's admirable.
Thank you.
I hope I keep saying this throughout the months of the Commission, but I'm saying it.
Well, you've now set a very high bar for me, so thank you, Commissioner.
And has someone gone for the witness? Oh, Ms McGuirk. Oath or affirmation, Ms McGuirk?
Affirmation, please, Commissioner.
Would you administer the affirmation, please?
Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr Gregory?
Thank you, Commissioner. You are Emma Kate McGuirk,
I am.
and you received a notice to give a statement and produce documents with the title NTG-0027,
I did.
and you produced a statement dated 21 October 2022 in response.
I did.
And that statement had an attachment which comprised a number of diary entries and emails.
Notebook entries, yes.
Sorry, notebook entries and emails as a single attachment.
That's correct.
Commissioner, I tender the NTG 0027, the statement and the attachments separately. I think, unless I've missed it, it's exhibits 137 to 139.
I think it's 136 according to this schedule, which I hope you've given a copy of.
It's 136.
Oh, sorry, I had 136. You're quite right, it's 137. So the numbers on this will be out by one, I'm afraid.
Yes, I think we tendered a document in the way in Ms Pulford's evidence wasn't anticipated by this document.
Yeah, I'll have to remember to make those subdivisions. So add one to everything in this schedule.
Thank you. And further...
137 to 22... sorry... 215, is that...
That takes us through...
Oh, no, I'm looking at the end of it. 137 to 150, is it?
Yes.
Okay, got it now. Thank you. Those are the exhibits.
Thank you. And I should just confirm, Ms McGuirk, you also received a notice to give evidence and produce a statement number NTG-0068, and you produced a statement in response dated 31 October 2022.
That's correct.
Thank you. And finally, I have been provided with an email trail by a senior counsel assisting the Commonwealth, which I understand you have produced between those statements and your evidence here today, which includes persons Gary Knox, P&I Coordination and others. Is that a document you're familiar with? You're looking uncertain. I'll have it placed in front of you.
Can I just check what document that is, please?
Thank you. Is this another exhibit again?
It will be, yes,
All right.
provided the witness does recognise it.
I recognise the document.
You do recognise it? Yes. And you can see that you're a party to the sequence of emails which are
Yes.
contained within it.
Yes, I can.
I tender that document.
That'll be 151.
Thank you. We'll come back to that document shortly, but in the meantime, as your statement sets out in response to NTG 0027, you were in a role relevant to this inquiry for only a short period of time.
That's correct.
It is between 22 December 2016 and some point in time in January 2017.
So I was officially acting in the group manager position from the 22nd of January until on or about the 16th of January. And then for a subsequent couple of weeks until the 3rd of February, the compliance section was reporting to me due to other people being on leave.
Right. And that period of about 5 weeks was the sum total of your involvement or association with what is known now as the Robodebt scheme?
That's correct. Subject to, in my statement at 18C.
That was a conversation with Mr Ryman in 2014?
Correct, but in 16-17 it was, as you said.
Yes. Right. If we deal then in chronological order with your association, and starting with paragraph 18C, you recall a conversation you had with Mr Ryman sometime in 2014 who raised with you the concept of data matching ATO information and comparison with that income records held by Centrelink?
That's correct.
And that you were working at that time in the means testing section at the Department of Human Services?
That's correct.
And the limit of that conversation was that you recall mentioning to him that the fortnightly income test would apply in a scenario where debts were being raised?
That I did mention the fortnightly income test was central.
Yes. And that had context because of the concept of comparing ATO data to entitlements under the fortnightly income test.
Annual based data, yes.
Yes. And that for that reason he would need policy advice from the department?
Yes.
And the department you are referring to there, is that the Department of Social Services?
It is, yes.
Right. Then we skip forward to December 2016 and you came into the role as acting group manager of the payments policy group at the department for a 3-week period, as you say.
That's correct.
Yes. And this is the Department of Social Services?
The Department of Social Services.
In that short period of time, you had a range of matters associated with the online compliance intervention program, as it was then known. You received briefings from the Department of Human Services.
Yes.
And you engaged with the Department of Human Services regarding letters and the 10% recovery fee.
Yes, that's correct.
And you obtained legal advice regarding the operation of the Social Security Act in respect of the elements of the online compliance intervention.
Yes.
And that was advice from Ms Pulford, I understand.
Yes, that was.
If we go then to the sequence of events, you say in your statement that you identified an email from 5 January 2017 from Ian Joyce, who was the Director of the Means Testing Policy Section, and he forwarded an email sent by David Mason to Andrew Whitecross in January 2016 regarding a proposal advanced by the department and the policy position of the Department of Social Services in respect of that proposal.
Yes.
The Commission has heard evidence about that, but it was part of the information you received for that short period of time that you were in this position.
Yes.
The next event of some relevance is the 15th of January 2017 teleconference.
Yes.
Can you describe the context in which that arose and who was involved and what was discussed?
So that was a Sunday, the 15th of January. The reason I was acting is because my Deputy Secretary, Serena Wilson, was on leave, and the person in the group manager role, Kath Halbert, was filling in for her, so I was filling in for Ms Halbert. Ms Wilson was due back at work on Monday the 16th. On Monday the 16th, there was a meeting scheduled with the Ombudsman's office in regard to their own motion inquiry. Considering Ms Wilson had been on leave, we met on the Sunday to just provide her with a little bit of background about the matter in advance of that meeting on Monday.
And did you make some notes in your notebook in respect of that meeting?
I did.
And they are the notes that appear DSS.5035.0001.0001.
Yes, they are.
And they follow over to 0002.
Yes, they do.
The persons present in the meeting, can you just identify those from your notes for the record?
That would be Melissa Golightly,
Yes.
Karen Harfield and Scott Britton from the Department of Human Services,
Yes.
Serena Wilson, Kath Halbert, Paul McBride, me and Murray Kimber.
And each of those second line of persons were from the Department of Social Services.
They were.
You make a note, parameters, more than $1,000, dates, inverted commas close, employer names, and is it
Vulnerability.
vulnerability indicators?
I apologise now for my handwriting at any stage in the next couple of minutes.
There's no need to apologise to me. This was essentially an update of information that you had received over the previous fortnight or so about the online compliance intervention program.
This was more to understand how the online compliance initiative was, or intervention was actually working on the ground, how it was being implemented.
And who was providing the information then if it hadn't been gleaned by you in the preceding weeks?
That people from the Department of Human Services.
So Ms Golightly, Ms Harfield and Mr Britton
That's correct.
were the ones speaking about the matters in respect of which you made the majority of these notes.
Looking at these notes, yes, I believe that's correct.
And again, this is not intended as any criticism, but just for accuracy purposes. Yes. Would you mind just reading your notes into the record?
No, that's
from
fine.
That meeting? Thank you. Just from the point of get a letter.
Yep, sure.
Thank you.
So parameters and then 4 dash points. More than $1,000, dates close, employer names, vulnerability indicator. Another point, get a letter asking to confirm, online just been introduced. Now no need to provide documents, variance accepted if close, in brackets 1%. Not averaging all the time, if left with no other option, average. Not income smoothing, using averaging where no other info. BMC meeting, confirmed, not minuted. Proportion people appealing, 1.6%. Review, average debt. Some media conflation of issues, student debt, FTB, age pension. 60% ex-recipient, normal debt notice, don't respond until account payable, in brackets, ex-recipients don't pay. 2.8 million, in brackets, last year this measure 100,000. We'll share brief screenshots. And that's the end of my notes on that meeting.
Thank you. Was all of that information provided by the persons from the Department of Human Services, to your recollection?
To the best of my recollection, yes.
The reference to the BMC meeting, do you now recall what that was about?
So BMC stands for the Bilateral Management Committee. And the Bilateral Management Committee is one of the governance forums that supports the bilateral management arrangement between the Department of Human Services and the Department of Social Services. So an MOU, if you will, between the two organisations about how the business of social security will be managed by the Department of Human Services. And the Bilateral Management Committee, BMC, is one of the senior level governance forums there.
Do you now recall the question of, or the issue of what was confirmed?
I don't have a specific recollection of what was or wasn't confirmed. I can't talk a lot more to that.
And as at the time of this meeting, you had some information that had been provided to you by Ian Joyce.
Yes, I did.
And what did that information comprise?
That information was about original advice provided to the Department of Human Services in 2014, or correct myself, information about the advice on the matter. I can't recall directly, because there are so many different pieces of advice, whether that was information that had been directly conveyed to Human Services or not. That's the David Mason advice, am I correct?
All right. That advice was an advice within DSS, to your recollection? Or you're not now sure?
So I can't be sure now which piece of advice I'm considering, about whether it was purely internal or whether it was a piece of advice that had been conveyed to the Department of Human Services, because there was a range of advice that I had collected to provide some information to me and to also Ms Halbert. So that particular one, I can't remember.
All right. To the extent that you've been able to identify the advices that you collected, you have done so in respect of the emails that refer to them? In this statement, the emails to which you refer?
Yes.
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 All right. Do you recall whether the advice from Mr Mason from 2014 became a topic of discussion in the meeting on the 15th of January, on the Sunday?
I don't recall that being discussed. My notes don't indicate that.
All right.
No.
Likewise, you refer at paragraph 19b to a PDF comprising various internal policy advices, which include one dated 18 December 2014, and we've heard that that was generated by Mr Jones and Ms Pulford. Is your answer the same in respect of whether that was discussed with DHS representatives on the 15th of January 2000?
Yes, I don't have any recollection that it was, and there's no reference in my notes.
All right. Continuing with your notes then, there was the meeting with the Ombudsman on 16 January 2017.
Yes.
And for context, do you recall the significant issues in the media that were being raised about the scheme at this point in time?
I recall that it certainly, the matter was, had gained reasonable media attention, that there were interviews with ministers about the matter, and certainly from refreshing my memory with my notes, it certainly appears that media interest in the matter had been escalating.
And in that context, the Ombudsman had initiated its own motion investigation into the scheme?
Yes.
And it was within that own motion investigation that there was the meeting on 16 January?
Yes.
Again, no disrespect, but could you please read your notes of that meeting?
Sure,
to the
not a
record?
problem at all.
Thank you. It commences DSS 5029 0001 031. 0031.
Ombo meeting 16.1. Matt Roper, Stephen Avery, Kath, Serena, EK, Scott Britton, George Masri, Louise McLeod. Richard Glynn, Acting Ombo, Internal Discussions, Broad Scope. Briefing with DHS a week and a bit ago, system run through last Friday, discussions on own motion discussion. Initial view of Acting Ombo two-pronged. 1. First report, high level, in February. Keep lines of communication open. Test conclusion with departments. 2. Specific areas of detail, longer time frame. Later this week, we'll have clarity about scope looks like, what information is required. Roundtable with community orgs Wednesday via videocon in brackets consultation process. Focus will be on implementation and service delivery. Keep up with DHS on enhancements to systems. Serena Colin. 15-16 budget, range of measures requested by government, DHS in particular on strengthening payment integrity and better debt. Opportunity to use ATO data, levels of income and periods of employment, test, interim process while. MyEFO 15 and MyEFO 16 based on pilot experience. In NPP developed by DHS, no change to approach for assessing debt. Change, volume, use of data, phone or online. Augmentation of approach, scale. Measure assumed level of review requested, running lower than we thought. Complaints and cases in media, different measures conflated as this. Some confusion in press, in brackets Ombo agreed. They are clear about scope for this investigation. Ombo met with Auditor General, Office of Information Commission, Inspector General of Taxation, in brackets. They have jurisdiction over ATO. George Ombo. We are focused on implementation, core. Risk assessment, governance, checks and balances, reconsideration versus review. DHS defines complaints probably a little narrowly. No issue over broad policy of debts to Commonwealth being recovered. What provisions were used? Were there other provisions that could have been used to recover? Going back 6 years, concern people may not have documents. Serena. Vulnerability. People excluded in our understanding, in brackets. Yes, Ombo knows, but interested in people above this, people with no capacity to verify. Clarity over reviews. How does ODM work when decision made by computer? Serena. SBDs and BMC meetings, line of sight to appeals data. This didn't become an issue until late last year. Ombo. Started to get complaints from mid to late October, or Oct, but they ranged up as media ramped up. Matt will be co-ord point. George, if there is anything you can think of that would be useful, happy to have it.
Can I pause there? This was, it appears, as might be expected, a meeting with multiple people, different people having inputs and questions throughout those notes.
Yes, I mean, there are specific elements there where I've particularly quoted Ms Wilson or Mr Masri, but yes.
And if we go to page ending 0032, where you have, partway down the page, noted Serena, colon. Further down the page, you have an underlined passage in NPP developed by DHS, no change to approach for assessing debt.
Yes.
Was that something communicated by Ms Wilson?
As I interpret my notes, yes.
The change, colon, was to the volume and use of data, phone or online, and an augmentation of approach scale. Did you understand what was being conveyed by Ms Wilson was that fundamentally there was no change in approach, but there was just a higher level in terms of the volume of interventions?
While I can't specifically recall that, my interpretation of that, I think, would be about the change from the pilot program to the move to being fully online.
Can I take you over to the next page, 0033. Partway down the page, about halfway, issue over broad policy of debts to Commonwealth being recovered. Is that the line? About halfway down? Or no issue over broad policy?
No issue.
Who said that?
I can't say for sure, but again, interpreting my notes, I believe that was Mr Masri.
And what was his role, do you recall, at the time?
He worked for the Ombudsman's office, conducting or assisting to conduct the own motion inquiry.
Did you understand what was being communicated at that point was that the Ombudsman was not taking any issue with the policy, of broad policy of debts of the Commonwealth being recovered, or that it was a reflection that someone had said there was no broad policy issue in respect of that by the Commonwealth?
Sorry, could you just repeat what you're trying to ask here?
I'm trying to clarify whether that's a statement made in respect of the scope of the Ombudsman's inquiry or a representation by those who were in the meeting on the part of the Commonwealth, whether the Commonwealth itself was saying there is no issue, no policy issue broadly with the approach that we're taking, or the Ombudsman is saying we are not taking issue with the policy approach.
So my interpretation of my notes is that it was about the scope of the own motion inquiry, that it wasn't about the broader policy of debt management in the Commonwealth.
And going then to the row below it, or the note below it, what provisions were used? Were there other provisions that could have been used to recover? Is that a question relating to scope on the part of the Ombudsman?
I believe so, yes.
That is, the Ombudsman was looking at provisions in acts which were social security law, which was relevant to the question of recovery.
I believe, as I said, I don't have full recollection of everything in this meeting, but my interpretation of my notes is that, yes.
Okay, thank you. If we go over to page 0034, you have the heading Scott and a series of notes there.
Yes.
That's Scott Britton.
Yes.
Are these notes attributed to communications or information he provided?
Yes, I've put a line underneath there, so this would be a separate meeting that I would have had with Mr. Britton. I have no independent recollection of the meeting, so I can't say if it was on the phone or face-to-face.
Certainly. The third line is that the government didn't want burden on employers.
Yes.
And you understood that to mean that the administrative process of clarifying whether a debt existed or not was transferred to recipients through an online process.
That's my understanding of what that point means.
Yes. All right. Following the scope of the Ombudsman's inquiry, which was indicated to you in that meeting and others, to include what provisions of social security law were used in the process or relied on in the process, did you approach Ms Pulford to obtain legal advice?
So I have no recollection, as I think I've indicated in my statement, of exactly when I approached Ms Pulford. I don't know if it was after the Sunday meeting, so whether it was, you know, the Monday the 16th, Tuesday the 17th, I don't have any notes of when that was or any recollection of that.
Okay. You did have at the point when the Ombudsman meeting occurred the 2014 legal advice, second counselled by Ms Pulford.
Yes.
Did you raise that in the meeting with the Ombudsman, that there didn't appear to be any identification so far as your information so far as you were able to ascertain in the few weeks you'd been in the role, that there had been any advice about what provisions might be used?
There's nothing in my notes, and on this particular meeting, I think I've kept fairly comprehensive notes of what occurred, and it's not raised in my notes, and I don't have any recollection of us discussing that.
Okay. If we go to Exhibit 151, which was the email that was handed to you separately, it won't be in your bundle. The last page of that email is an email sent Friday, 13 January 2017. There are various recipients to it, but the subject is, including yourself, the subject is action required, Secretary meeting with Catherine Campbell, DHS Secretary, and there's an indication that the Secretary of the Department of Social Services, Mr Pratt, is meeting with the Secretary of the Department of Human Services, Ms Campbell, on Monday, 23 January 2017, and a request for dot points on hot issues that you would like Finn to raise with Catherine, or anything else he should be aware of. Now, the you there might not be specifically you, because you were copied into the email, not the direct recipient of it, and there were a number of people addressed there. But is it the case that you ended up developing the dot points ultimately?
I certainly have cleared the dot points. I don't believe I had anything to do with writing the dot points, but this email certainly indicates that I cleared them originally by phone, so I was technically on leave on that Thursday the 19th, but from other emails I've sent on that day I was doing some work, and then I've followed up with an email to Mr Knox as well.
All right. The ultimate email containing the dot points is dated 19 January 2017, at least in this sequence of events.
Yes.
The first dot point is senior departmental staff were given a run-through of the Human Services online compliance system at TOP on Wednesday, 18 January 2017, and are comfortable that the current process is lawful and clear. What's TOP?
That stands for Tuggeranong Office Park. That's the building in which we worked.
And who is the reference to senior departmental staff? Perhaps I should say this, did it include you?
Yes, it did.
Right. In that meeting, when those staff became comfortable with the current process being lawful and clear, was there any discussion of the advice from 18 December 2014.
So I don't have any recollection of that advice being discussed at that meeting, and there's no reference to that in my notes. Also, I don't necessarily think the comment about being comfortable is just in relation to the meeting. So I think it relates to the senior departmental staff are comfortable. They are also, the meeting was part of it, but I don't know that that represents, the level of comfort doesn't necessarily just relate to that meeting.
Right. But the question of the lawfulness or clarity of the process, do you recall what happened in that meeting which led to that as a talking point?
Not in that meeting of Wednesday the 18th of January, no I don't.
Prior to that time, was there discussion of lawfulness with senior departmental staff, to your recollection?
So I can't recall a specific discussion other than, and I can't put a time or a place around it, a discussion that I had with Mr. Kimber in relation to the email that he sent on the morning of Sunday the 15th, where he provided some recollections, and I know there must have been other conversations, but I don't particularly recall any one conversation.
Right. In the conversation that you had with Ms. McGuirk, Ms. Pulford, Ms. McGuirk.
Yeah.
In the conversation you had with Ms. Pulford where you requested additional advice,
Yes.
do you recall saying words to the effect that there was a departmental business need to have some means of legally justifying taking action of this nature in these circumstances, that is, taking action in respect of raising debts in an online compliance environment?
So I said before, I have no recollection of a particular conversation where I gave Ms. Pulford verbal instructions. Given the email I sent her, I assume there was a conversation, but I don't have any recollection or any notes of that conversation.
Do you recall generally that following the conversation with the Ombudsman on 16 January, that there were discussions within the department which pointed to the need to have evidence relating to the legal basis of it, that is the provisions of the Social Security law, which would justify the scheme?
That in seeking the advice, we were wanting to understand the component essentially that was new to our understanding, which was raised in that 15th of January meeting, where the Department of Human Services told us that they weren't averaging all the time. If left with no other option, that's when they were averaging. That was something that that concept had not appeared to have been contemplated before. And my recollection is we wanted some legal advice to help us understand the lawfulness of that practice.
That is, you understood that information in the terms that you've read it out to convey something different to the smoothing that was discussed in the lead up to the 2014 advice.
So our understanding... Sorry, can you repeat the question? I just want to make sure I answer you correctly.
No, that's all right. There was obviously some distinction in your mind between what you were told by DHS in the meeting on Sunday the 15th
Yes.
compared to the history of, or the emails leading up to the 2014 advice. Hence the need for an additional advice addressing something different to your mind.
So the 2014 advice that had been provided to Human Services was very much focused on the fortnightly averaging concept. We understood from the material that we'd gathered that Human Services had not amended or didn't find a reason to amend the way that income was assessed and debts were raised. So that they had essentially taken on board that 14-15 advice. This piece of information was essentially a new concept to us, this idea that it would be used where there was no other information available.
Okay.
I'm a bit confused, sorry. The 2014 advice said averaging probably didn't comply with the Act, in effect, I think. I'm summarising.
Broadly, but that was in relation to the specifically what the Department of Human Services had described as the process that they were planning on taking, the process they were planning to put forward. As we understood it from the documents we were looking at, we believe they had taken that advice on board.
What did you think they were doing then? Not averaging at all, or...?
Well, at that point, so I was new to this, Ms Halbert was new to this. We were only relying on the few documents that we were able to put together. From those documents, we understood that that initial advice, the Department of Human Services had taken that on board and were implementing a system in accordance with the legislation so that the way income was assessed and debts were raised, there was no change to that. That was our understanding.
No change from what? From what they'd done pre-2014? Or...
Yes.
And what did you understand that to be?
That debts were calculated based on information provided or various sources of information about where, when income was earned.
Okay, so this idea of just averaging ATO data and having no other source of information was news to you in 2017?
So the understanding that I believe we had at the time was that it was, the averaging information was essentially used as like a trigger.
Sure, a flag that there's an issue.
A flag for, well, there may be an issue. So a trigger to potentially look at whether or not someone had an overpayment or underpayment. So that was how the averaging was being used, because we believed from the documents that we had that there had been no change to how income was assessed for the purposes of raising a debt.
So you didn't have any reason to think that averaging was being used to raise debts? Is that what you're saying? Until you discovered this in 2017? So
I can't speak to what the department was thinking in between the 14-15. As I said, I was in this space for a small amount of time, so I'm just talking about in January 2017, gathering a few documents at the time. There were a lot of people on leave. We were just doing what we could. So Ms Halbert and I could try to understand what advice may have been given, because there was no one working at that time of year who had a contemporary memory of it. And our understanding from those documents was that, yes.
Okay, thank you. Mr Gregory?
And did your understanding then shift, you say, in the meeting with DHS where they said nothing's changed, but we do use it as a last resort?
So that certainly was not a piece of information that I can see in any of the documents we had to inform ourselves prior to that meeting, yes.
Right. You ended up getting the advice from Ms Pulford. I'm sorry again. We've been going since 9:30. And soon after that, that is 3 February, you ceased any association with the scheme and involvement with the Ombudsman's inquiry?
I had no further involvement.
To your recollection, or to your knowledge rather, do you know whether the 2014 advice, including the policy advice, either or, was provided to the Ombudsman?
I know now that yes.
That happened?
That happened, yes.
And how do you know that now?
I've been made aware of when that information was or emails that indicate that information was provided.
Okay. And those are the ones that you've attached?
To my second statement?
To your second?
Yes.
Yes. All right. Thank you. No further questions?
All right. Ms Hogan-Dory?
Commissioner, if I may, Ms McGuirk, I just want to clarify something small in relation to some evidence you gave in the beginning concerning paragraph 18C of your statement, which was a conversation in 2014 with Mr Ryman. Do you remember that evidence?
Yes.
You told the Commissioner that you told Mr Ryman to get policy advice from the DSS. I just want to check, was that only policy advice, not legal advice?
So I suppose when we use the term policy advice in the Department of Human Services, it would have comprehended potentially legal advice as well as interpretation of the legislation. So it's just the phrase that we used when we were saying you better go to the policy agency. It would have been to get policy advice. So that potentially would have incorporated legal advice.
All right. And both you and Mr Ryman were in DHS at that time?
We were.
All right. And you said to go to DSS. Could you just explain further to the Commissioner why DSS are not within DHS?
So the Social Security Act, Social Security Administration Act were owned by the Department of Social Services. Department of Human Services had purely had a service delivery and program management function. So any advice on the interpretation of the legislation, policy advice, as I said, we would go to the department where there was no precedent, if you want, for advice. So that's why I would have suggested it.
You said in your evidence that the conversation was in 2014. Are you able to assist the Commissioner at all to place when in 2014?
Well, I'm fairly sure it was 2014. So I started in the Department of Social Services in June 2015. So I definitely know it's before then. And my recollection is that Mr Ryman was talking to me about this concept in the design phase. So that's why I interpret it was in 2014.
And when you say this concept in the design phase of what?
This initiative he mentioned to me where they would be using more data from the ATO to potentially look at potential debts.
Did you have occasion after 2014 to recollect this conversation?
So I remembered the conversation when I became involved again. So when I put it into the statement, I was remembering that I remembered, if that makes any sense. And at the time it came back to me.
And was that in the context of remembering the events of 2017?
Yes, in remembering the events of 2017, I remembered at the time I recalled this discussion with Mr. Ryman.
And in recalling... Oh, all right, that's all I wanted to ask. Thank you, Commissioner.
Mr.
No, thank you, Commissioner.
Anything else, I presume, Mr. Gregory?
No, Commissioner.
Thanks very much for your time, Mr. McGuirk. You're excused. All right, we'll adjourn for the day, unless there's any housekeeping or anything.
Commissioner, I think that ends the interest that my client has in the coming witnesses. I was going to ask if I may be excused.
Yes, of course, Mr. O'Neill. I don't know
Please.
if at some stage Mr. Gregory might make some submissions about your client's evidence, but I guess you'll be given notice if that's likely.
I'm sure he will give him, given my limited experience of him, he's very genteel. He'll let me know.
All right, thank you. So we're finished for the day?
Yes.
Yep. 10 o'clock tomorrow.
All rise. The Commission stands adjourned until 10 a.m. tomorrow morning.